Good morning, everyone. Welcome to today's committee meeting. I would like to first call to order and request that Ms. Wong please do a roll call of the group.
Will do, Mr. Chair. James Bolton.
Here. Did you hear me?
Yes, I did.
Okay.
It looks like Kim may be frozen.
Yeah. We lost Kim.
I apologize. I'm not sure what happened. James Bolton,
Here.
Robert Brody,
Here.
Michael Cow,
Here.
Alex Chen, James Afting,
Present.
Karim Gongora,
Present.
Dolores Heisinger,
Here.
Judge James Herman,
Here.
Michael Iseri,
Here.
Larry Kaplan,
Here.
Paul Kramer,
Here.
Esther Lynn, Anthony Pick,
Here.
Vince Reyes,
Here.
Judge Shelley Toliaba,
Here.
David Torres. We have a quorum, Mr. Chair.
Thank you, Ms. Wong. So we'll now move on to call for public comment. And as noted on today's agenda for the meeting, during the meeting, public comments will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments, and we thank you for that. The committee coordinator will attempt to call members of the public in order that they appear. Due to the number of people requesting to make public comments, we ask that you limit your comments to 2 minutes, and to facilitate hearings as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that we will be addressing today. We'll not be able to hear more than a maximum of 15 minutes of total public comments. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. Coordinator will call members of the public in order that they identify raised hands and will enable the microphones of the speakers. So at this time, Ms. Wong, do we have any public members wishing to make a comment?
Yes, Mr. Chair. We're going to start with Pete Bennett. You have 2 minutes, Mr. Bennett. Mr. Bennett, are you there?
Okay, do you hear me?
Yes.
Thumbs up.
Yes.
My name is Pete Bennett. I'm a resident of Contra Costa County. I'm a litigant with 40 years worth of history. My witnesses have been murdered. My attorney has been murdered. My family has been murdered. My other attorney's son was murdered. Another attorney's son was another brother-in-law attorney was murdered. I'm very familiar with the Contra Costa Bar Association. In fact, I have a blog called deadwitness.com. I have another blog called pgewitness.com. My attorney has been beaten up. My family of 5 was murdered in Utah. I worked on Oracle v. PeopleSoft.com. They have been trying to kill me ever since 2004. That would be Larry Ellison, who defrauded this court in the 2000s. Oracle software was pathetic. I'm a software developer and now I'm homeless. I endure beatings. I've had guards breaking my ribs. I had a guy try to drag me down on the ground and kill me in Walnut Creek Public Library. I have spoken 50 or 60 times, Contra Costa County, the Walnut Creek City Council. I've left a trail of breadcrumbs a mile long. I cannot win in a courtroom. I have 8 murders in my civil litigation going back. I lost Bennett v. Southern Pacific when they killed my witness in 1989. It's all been covered up. I have reached out to the Bar Association. I have lost millions. Beautiful children have been killed. It's nothing but a lie everywhere. This is not a courtroom. I had one judge take my license for 16 years, kept adding fines. He should be disbarred. Judge Joel Gulip. I know who
Mr. Bennett,
blew
your
up the
time is
pipeline.
up. I'm sorry, your time is up. Can you wrap up your comments, please?
Yeah, you can reach out to me, 925-357-0723, before they kill the rest of my family and my sons. I am dead serious about what's going on.
Thank you, Mr.
It's
Bennett.
disturbing.
The next public comment is from Julian Sarkar.
Thank you, Ms. Wong. Good morning. My name is Julian Sarkar, and I represent attorney applicants against the State Bar of California and National Conference of Bar Examiners' unlawful practices. In the past years, we've seen a disturbing disregard for the law by the Office of Admissions as supervised by this committee of bar examiners. Meeting minutes have been falsified to reflect decisions that were never noticed on the meeting's agenda and never discussed at the meetings. Applicant exam scores were tampered with in the Ames database immediately following the Supreme Court's decision to adjust the cut score. Section 6060.3 of the State Bar Act requires the State Bar to adopt regulations for applicants to obtain refunds when serious illness, disabling injury, or death of an applicant or their family member prevents the applicant from taking the exam. But the State Bar has refused to comply with our legislature's demand that it do so. The State Bar executives and employees are continuing to aid and abet the National Conference of Bar Examiners violation of our state's conflict of interest laws set forth in Government Code Section 1090 on our Supreme Court's Blue Ribbon Commission. I understand the State Bar has put out an advertisement seeking to hire yet another attorney to protect it from the Office of Admissions' pattern and practice of defying the law, and that the State Bar is planning to proceed with a high-risk, in-person COVID super spreader event despite the recent developments in the pandemic. Because the State Bar has never demonstrated the validity of the bar exam and continues to outsource its development to the NCBE, a private Wisconsin corporation run by attorneys who have never even tried to take a bar exam, I can only conclude that the State Bar's primary motive in proceeding with the exam is the tens of millions of revenue dollars taken from applicants each year. I understand. I like money too, but I don't knowingly and deliberately try to take it from vulnerable populations in ways that are dishonest and harmful the way that the State Bar Office of Admissions does. Among other reasons, because that would create a high risk of other people coming after me and actively trying to bring me to justice for doing so. Those people are lawyers, at least the ones who still honor their oath to the defenseless and the oppressed. I see some of my clients' litigation against the State Bar is on your meeting agenda for today and tomorrow. I ask this committee to seriously consider the potential savings and increased profits that could be realized by a non-exam alternative. I'm pleased to inform you that you already have a perfectly good legal team, so I'm not sure how hiring a new lawyer will prevent the State Bar from insisting on defying the law. Consider instead the potential savings and financial benefits of complying with the law, as well as a non-exam alternative. Thank you.
Thank you, Mr. Sarkar. The next public comments is from Dean George Leal.
Good morning, everybody. This is George Leal. I'm the Dean of the Irvine University College of Law, and appreciate the opportunity to speak briefly this morning, and want to speak about a relatively uncontroversial issue before you. It's agenda item 0402. This is I strongly support the staff's recommendation to take action that frankly is long overdue. This is a temporary waiver that's been in effect since 2009, when the committee then waived the restriction in unaccredited guideline 1.11 that prohibits schools from granting credit to their students who take either a review course for the first year law students examination or a review and prep course for the bar examination. That waiver went into effect, and for better part of at least a dozen years, a number of unaccredited schools have programs and have been offering credit for these programs. It only came to light relatively recently that there was a bit of an anomaly. The written guidelines in paper form had an express footnote that noted that this waiver had been temporarily suspended. I'm sorry, that the restriction had been temporarily suspended. And what was posted on the State Bar website's version of the rules did not have that. So the committee could take action by affirming first, continuing the temporary waiver, and then going forward, as staff recommends, to make a permanent amendment. In support of that, it's simple. If you would help us and continue to help us achieve the State Bar's goals of equity, inclusion, and diversity for my school with a highly diverse enrollment, providing credit and providing programs that allow our students a better opportunity to pass the first year exam and the bar exam is essential for their success. And this idea of providing such preparation and review sessions is now in the world of the Cal Accredited school. The newly adopted amendments to the rules provide essentially unlimited amount of credit. There's no limitation. There had been a prior limitation. So all we're asking as the deans of the unaccredited schools is to stand on an equal footing with the Cal Accredited schools. And by the way, as we had a discussion a couple days ago at CS Bars, it's now widely understood that bar preparation is now a core element of the ABA curriculum, and the ABA.
Can you please, your time is up.
Thank you very much. Appreciate the opportunity.
Thank you. The next public comments is from Christina Chong Nakasuchi.
Hello, can you hear me?
Yes.
Hi, so I work for the Monterey College of Law. I'm the Associate Dean of Academic Affairs. I've been working in academic and bar support for about 10 years. And similar to Dean Leal, I've worked for, I've had experience working at the ABA accredited schools across California. I've worked for 3 or 4 of them. And I can confidently say that, as you mentioned, in these ABA accredited schools, it's become a normal practice to offer bar prep courses for unit credit for upper division years. And I think changing the rule would take us out of alignment with the other top schools and what they're doing. And this is all covered in Chapter 3 of the ABA rules. Specifically, they're requiring even more academic support for students in law school. And second, I wanted to talk about the requirement that we might not be able to allow for unit bar prep courses, specifically speaking about how students might feel about this, because I've worked with thousands of students in my career. And based on these conversations, I can confidently say that many of the students have enjoyed having the option to take unit credit for bar prep courses because it gives them extra accountability, time to prepare while in law school, not just the 3 months before the bar, and it's helped them really lower their anxiety. And if we took away the option for schools to offer 4 unit credit bar courses, I really think this could be detrimental to the education of the students, especially the struggling students and non-traditional students, which is the large population of the Cal's accredited school, because these students are already stretched thin when it comes to time, and they struggle to even pass and satisfy the required electives and courses. So if we can't offer, actual credit courses and we have to do voluntary courses, it's less likely these students are going to sign up because they just don't have the time, or they'll sign up and they won't actually participate because it's like not for credit and it's lower on their priority list, even if they want to participate. But these students are statistically more likely to fail the bar on the first attempt, and they need the help. So when I worked for ABA schools, when we started offering these courses for credit, it really was a great tool for the students and for the faculty, because we saw an increased correlation in first-time bar passage rates, especially for the bottom quartile, the struggling students, and I studied this. So I really think it would be helpful.
Wrapped up your comments?
Yeah, that's it. Thank you so much.
Thank you. The next public comments is from Benjamin Cohn.
Hello, thank you. I wanted to comment about the options being discussed as contingencies for the February 2022 in-person bar exam relative to the pandemic. I am wanting to urge the state bar and the committee to help lobby and request the county and state health departments for a public health order that would allow it to satisfy the NCBE's demands in order to offer a remote exam alternative in March to those applicants who may be immunocompromised or just concerned with Omicron about their health and wanting to take the exam remotely or need to take the exam remotely according to their physicians, which is currently not being entertained as a disability accommodation improperly under the state bar's policies. I also wanted to encourage the state bar to consider implementing a contact tracing policy in order to make any in-person exam more safe. Then secondarily, I see that there's a strategic planning agenda item that includes aspirations to consider planning proposed amendments to the admission rules to make testing accommodations more streamlined. And I would encourage the committee to remember and go back to and consider written comments I've submitted a few times in the past regarding what those admission rule amendments should look like to better and more fairly reform the state bar's testing accommodation procedures and practices. Thank you.
Thank you, Mr. Cohn. Our last public comment is from caller user ID T.
Hi there, can you guys hear me?
Yes.
Hello, can you hear me?
Yes, we can.
Great. So I just wanted to also comment on the response to the current climate, the pandemic climate. So we've been living with COVID for years now, and the Omicron variant is still highly contagious months along, and there's even a new variant that's at risk, BA.2, which has been detected in Northern California. I speak on behalf of a lot of other immunocompromised individuals that the bar has to do more to protect us and those around us who are also immunocompromised. So in terms of protection, as the previous speaker was talking about, at the very least, I think we should do contact tracing, because we don't really know to what degree we can hope that people are following the policies, because again, those who have been vaccinated and boosted can still get infected. Alternatively, those who provide a negative COVID test can still get infected between the time of their COVID test and exam day. And it's almost inevitable that many who are unknowingly positive and asymptomatic will attend. And in more dire situations, applicants who doubt that they're infected but hesitant or unable to cancel for whatever reason may still attend to avoid having to wait months to have another opportunity to sit for the exam. Masking is not enough to prevent infection. We've seen that around the country. We've seen that internationally. And I think California needs to follow Nevada's example and allow for a remote option, even if there's some delay, so that those who want or need to avoid a potential super spreader event have the option to do so. That's pretty much all I have to say. Please look out for us that, have health conditions and those who are surrounded by those who have health conditions. So thank you.
Thank you. Mr. Chair, it's about 9:20 now. At this moment, would you like to continue one more public comments, or should we conclude the public comments?
We can continue with the public comment. Yes, I do see one more, so yes.
So Miss Charlene DeLarences.
Hi, there. Can you hear me okay?
Yes.
Hi, yeah, it's Charlene DeRosendez. Hi there, thank you. I want to thank you for your service. I'm a former elected official. I was not appointed and I served on over a dozen county and city boards and commissions and very involved in political campaigns. Specifically, I served on a 9-month open government task force. I want to encourage you to have more transparency, more public comments. I thank you for extending the time. I have 3 quick things I'd like to address. I support everything the last speaker said regarding the test in February. I am one of the people taking the exam. While I may not be concerned for my own individual safety, I am concerned for my fellow exam takers. At the very least, I think everyone, including those who have been vaccinated, should be tested because masks are only 95% effective if they're worn perfectly. And so that's between 5 and 10% of those taking the test are going to get sick. The current policies are in place for groups that are only meeting for a few hours, like a sporting event, and not somebody going to be in a room or a large room indoors for 8 hours, 2 days in a row. The second thing I wanted to address quickly is that I think there needs to be a third-party investigation on ADA accommodations for test takers. I will give you a quick example. Twice in a row, I've been denied my accommodations only because of policy being wrongly implemented. Once I brought this issue to the director of admissions, it was corrected, and I do have my full accommodations. I've worked with people with disabilities for the last 10 years. I know what I'm talking about. I've also worked as a private investigator. Something needs to be done. I should not have to not receive a phone call or return email for 2 to 4 months. There's not enough staffing in the department. There should be at least one person for every 100 applicants applying for accommodations minimum. The last and final issue on the report that you're going to be reviewing today, page 24 for the July 2021 bar exam, it's missing the technical issues caused by significant delays in the exam applicants from navigating between the essay questions and the page screen. It was not just the freezing of the screens. It really should be noted and made public, all of the technicalities, how many people that had some difficulties, whether it was a frozen screen or just the slowness of navigating between the pages, how many of those applicants did not pass the exam. I think there's a lot of information
Please
missing.
wrap up your comments.
Thank you. Having only one paragraph addressing that issue, I think, is not being as transparent as I implore you to be. Thank you so much. And again, thank you for your service. I know it's a challenge.
Thank you. Mr. Chair, we have concluded the public comments period.
Thank you, Ms. Wong, and thank you to all those in the public who have shared their comments. And at this time, we're going to look at the next item, approval of December 3rd, December 4th, 2021 Committee of Bar Examiners Public Meeting Minutes. Is there a motion from the group?
So moved. This is Kareem.
Michael is second.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Kao,
Yes.
Mrs. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Lin, Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba, Mr. Torres. The motion passes.
Thank you, Ms. Wong. So at this time, normally we would go to the next item, planning session discussion. That is stated to start at 10 a.m., but I'm going to ask Ms. Nunez to provide a report from the director.
Thank you. And Kim or Devin, I think one of you have the PowerPoint. Okay, perfect. So the first item I want to highlight is the key statistical indicators. These include the months of November and December 2021. So just as a background, our the next slide, please. Our key statistical indicators report capture the number of applications received by the office.
I think that might be the wrong slideshow.
I'm sorry, that's, yeah. Devin, do you have the one this morning from Amy?
Yeah, that was the one that I received.
I can share a screen.
There we go. Okay, thank you. So as I was mentioning, the key statistical indicators report capture the number of applications received by the Office of Admissions to date, along with last year's count. And this, as I mentioned, is a reporting period for November and December 2021. So it really encapsulates all the year-long progress and summaries of these applications. So the applications that experienced at least a 15% change when compared to previous years are highlighted here. As you can see, the applicants that have been placed on the motion by year end in 2021, there's a 75% increase in the number of applications compared to 2020. And this, and as I've highlighted at previous meetings, is caused by the postponement of the July 2020 bar exam. When that exam was postponed to October 2020, it delayed the results release. So rather than releasing results in November of 2020, the release happened in January 2021. And what that did is it created a reduced number of applicants placed on the motion in 2020 and an increase in 2021. And that is what that differential represents. What we anticipate is that the numbers will be more consistent in this year, starting in 2022, than what is reflected in these reports. As for applications received, in terms of differentials with greater than 15%, the number of attorneys has reduced about 21% compared to December of 2020. Along with attorney examinations, a 19% decrease in 2021 compared to 2020. And just as a background, the way those two applications are correlated, an attorney must register with the Office of Admissions before registering for the bar exam. So that's the difference between those two applications. As for moral character determination extension applications, we received 30% less in 2021 compared to 2020. And this may be attributable to the PLL program. The MJP applications, we had 48% less this year compared to last December. And lastly, the ProHoc Vice applications, we received 22% more during this period compared to December of 2020. All right. The next item is just a review of the March 18th CBE meeting. Our next meeting is scheduled for as a Zoom meeting, and that is scheduled for March 18th. The second calibration of the February 2022 bar exam is scheduled for the following day on Saturday, March 19th. Committee members are invited and encouraged to attend that session, and we'll be getting information to RSVP in advance of that meeting. And as I mentioned, we're going to continue safe practices for public meetings. And so given our current conditions, that meeting will be scheduled as a Zoom meeting. All right, we're going to move on to.
What's the date again?
March 18th and 19th. Okay. All right, so now provisional licensing, it should be the next slide. Just a quick update on where our current statistics are. Currently, we have 878 active applicants participating as provisionally licensed attorneys. And we have a total of, to date, 921 PLL applicants who been admitted to the bar. And the breakdown between those that have been admitted based on the expanded pathway, there are 307 provisionally licensed attorneys who were eligible under the expanded pathway, meaning that they did not have to pass a bar exam. They worked for 300 hours and got a positive reference from their supervising attorneys. And 614 that have now been licensed, after passing the bar exam. They were eligible for the PLL program as a 2020 graduate. All right, next item. This is an update on the Blue Ribbon Commission. I would hand it off to Alex and Esther, but I believe they are not available, but I can update the team, the committee on this. So we were scheduled to meet in January. That meeting was postponed, and we are scheduled now to meet on February 7th and 8th. The non-exam subcommittee is scheduled to meet on the 7th. And at that meeting, we're going to be providing information about the types and amount of experiential learning that's currently available or required by all California law school types. A presentation from deans and staff from ABA accredited schools, California accredited schools, and registered schools will be presented at that meeting. It's building off of the presentations provided by Canada's articling programs and Oregon's curricular and experiential learning requirements. What we do is we're trying to seek and learn about the types of experiential education and methods currently being offered. One of our BRC members will be presenting on a program currently run in California for 3Ls. A discussion on scalability and the potential of piloting a California program is also scheduled on that agenda, ensuring that we also leave enough time for a group discussion on these issues. For the exam subcommittee, they are scheduled to meet on the 8th. Staff will present survey findings about bar exam reciprocity and portability based on data collected from jurisdictions in December 2021 through early this month. This will allow the subcommittee to evaluate whether the ability for California law school graduates and law office study participants taking the bar in California, if they're able to port their exam score to another jurisdiction, and other factors on that decision on whether to move to the next gen or maintain a California-based exam. We're also going to be talking about the other exam factors, comparing the NCBE's position on remote testing, open book, and plans related to the grading and testing accommodations of the bar exam. We'll be summarizing also cost differentials and security between a remote exam and in-person, and what's more, leaving time for a group discussion and that has been scheduled on that agenda. Also, both subcommittees will be polled to assess their leaning on the various decisions for the exam pathway, whether to pursue a California exam or adopt the next gen exam. And for the non-exam pathway, should there be an alternative exam pathway? Should there be more than one non-exam pathway? And also whether the non-exam pathway be open to all or a subset of California law schools graduates or law office study participants. So that is scheduled again to happen February 7th and 8th for each of those subcommittees.
Amy?
Yes.
For my purposes in planning because this is not likely to come to us for any kind of formal recommendation, I feel obligated, as important of a question as this is, to kind of monitor what the commission is up to on my own. What is the current timetable? It sounds like your polling of them suggests that maybe the decision is sooner than I had been previously led to expect.
The poll is simply, we're still scheduled to meet until the end of the year. But I believe that the poll is to get some direction. What would have to happen next is that the groups have to meet together. So right now the subcommittees have been meeting independent of one another. We'll have a full BRC meeting to determine the next steps or any future presentations that are required or information that needs to be gathered. So this is just an interim step that we're taking to ensure that we're bringing the appropriate information to each of the subcommittees and to the full BRC.
Yeah, my only concern is the way these bodies work is when they make an interim decision, it tends to gather a lot of momentum, and it can be more difficult to steer in a different direction after that point.
Mm-hmm.
You know, towards the end, it's more about presenting it and getting input from all the interested stakeholders, but you know, it's quite often all a nearly baked deal at that point.
So Paul, is your concern about does it help that you'll be able to access the webcast?
Yeah, that's what I have to do. It's you know, it's hard for us to communicate to this body through our representatives. That's not an efficient way to do it, and you know, this is one of the key decisions that the bar is going to be making over the next few years, and I'm just trying to find a way to participate in a meaningful way. I guess I'm limited maybe to making public comments or making them through Alex and Esther.
Yeah, and that's what I was going to suggest is that there's always a public comment period, and I think participating as a CBE member would be useful, and also you know, through Alex and Esther.
Thanks.
Sure. All right. Any other questions?
Yes, Kareem has a question.
All right.
Awesome. Good morning. Thank you for your presentation. I noticed that we had a decline on attorney applications. Are those pretty common? I also know that we have the program for those attorneys that completed their hours. Did we see any progress on that?
So when you say there was a decline in attorney applications, I was referring to the fact that attorneys have to register in order to, with the Office of Admissions if they're going to register, for example, for the bar exam. And so that was the decline. And so the other part of your question, Kareem, you've mentioned is the other types of attorneys, right? Or I'm not understanding the second part of
Yeah, it's the one where they had to complete over 200 hours.
Oh, yeah.
I forget the name of it. I don't know why it's been a while since I spoke about it.
Yes, so the provisionally licensed.
There you go. Yes.
Provisional licensed lawyers. So I also highlighted that. So we have that application period for those under the expanded pathway closed in 2021. So what we have here highlighted is the number of those that have been or actively still participating because that program is scheduled to sunset in June of this year. We have 878 that are actively participating as PLL applicants. And that's a combination of those that qualify under the expanded pathway, as well as those that are eligible based on 2020 being a 2020 law school graduate. As far as those that have been licensed, there's a total of 921 that have been admitted. And of the 921, 307 are those under the expanded pathway and 614 are graduates. And as for whether that's the norm or not, this is a pilot program, the first initial program, I should say, of its kind. So there's no data to be able to compare that to.
Yeah, I was asking about the attorney registration. I mixed those data
Oh,
up.
yeah.
'Cause I noticed we're at negative 21%, and then we have declines in exam apps and moral character extensions and multi-jurisdictional practices. So I'm just thinking if that's a result of the holiday, or that's something that we commonly see.
There's been a pattern in the reduction of the multi-jurisdictional practice and pro hoc vice, a decline in MJP and an increase in pro hoc vice when compared to last year.
Okay, and I just want to say phenomenal work on the PLL program. I actually know someone who just recently was sworn in by the chairman of the Board of Trustees, Ruben Duran. And I can't say enough how much positive and really warm comments he said about the staff, the program. So just kudos to you all for making that happen. I know you did it all in a crisis, in a time where we didn't know where we were going, but I just want to say great job.
Thanks, Kareem. All right, so our next item is an update on the February 2022 bar exam. With that, I will hand it over to Audrey.
Good morning, everyone. Let me first sort of go over the numbers. So right now, as of this morning, we have 3,706 approved to sit the exam and 229 applicants pending eligibility. We have 243 writers at various test centers across the state, and the rest of our applicants will be taking the exam on a laptop. I also want to take a moment to sort of review our COVID policies for the exams, some of which we've had out since the exam application opened, about masking. So applicants will be asked to double mask, with at least one of those masks being a surgical mask, to wear a KN95 or an N95 mask. So these are the masking requirements we've put out in advance. We have additional distance between applicants. We have one applicant at the large test centers, one applicant per 6-foot table, which is quite an increase in distancing if you've seen the exam sites prior to COVID. Regardless of test center, all applicants are going to be required to provide proof of full vaccination or a negative PCR or antigen test. And we have alcohol wipes, hand sanitizer available at all of our test centers, so applicants can use hand sanitizer when they need to and wipe down their stations if they want to. We've put out our Friday emails, countdown emails to the bar exam. We started doing that a couple weeks ago, and we've updated all the applicants about how they're providing this proof of vaccination, which is through a third-party app called Clear. You might be familiar with Clear because they also do, if you've been to an airport, there's also Clear that is for travel, where you can choose them for travel, but Clear is also a vendor now that validates vaccination and COVID testing. So we've sent applicants all the information about how to use the app, and there's a couple of caveats. If you have the negative COVID test as how you'd want to prove entry, then you have to wait 4 to 8 hours if you're using a PCR test before the start of the exam on the 22nd, or 24 hours if you're using antigen tests. So those folks will be uploading to the Clear app sort of right before the exam. We did have a deadline or an important date this week, the 25th, where we started sending the applicants their admittance tickets. They can check the applicant portal, see their admittance tickets, see where their test center is. And we've added a field about vaccination status that is syncing with that Clear app. And if it says clear, that means we've received all your information about your vaccination status. If it says not clear, you need to go back and make sure you read through the instructions to link your vaccination status to our event code. It's all on a web page that we've sent out, a landing page on our website about how to do that with screenshots. And it'll continue to read not clear if you are coming into the exam with a negative COVID test as your proof of entry. So we're sending out another email today, kind of going over all those requirements, explaining what we need for proof of entry into the exam. On the 25th, we also sent out the list of approved laptop applicants to ExamSoft. So this week, applicants would have received an email about how to uninstall Exemplify, reinstall it. Because we are in person for this exam, the mock exam requirement is 1 mock exam, but you can take it up to 5 times. You can re-download it and practice before the exam. And then once you register your laptop by installing Exemplify, doing the mock exam, you also get to download the exam files. There's no live exam questions, obviously, that we've sent because people are coming in person and they're getting exam booklets. So it's a simplified process for the in-person exam with ExamSoft, but that did start to go out to applicants on the 25th. A change that we've made since we last met is that we did extend a deadline to withdraw, so with a full refund. So applicants were given until January 18th to withdraw with a full refund, which is far past our other deadlines for withdrawals for a February exam. And anyone who withdrew earlier and received only who received either 30 or 60% back, we actually went back and made all those people whole and gave them a full refund as well. So we've changed a few things to hopefully benefit the applicants in their decision-making and for the in-person exam. Any questions?
I don't see any.
All right, thank you.
And Amy, you want to finish up with any recent developments?
We don't have recent developments at the moment. What I'm thinking is we have one of 2 options. We could either move on to another agenda item or take a break before we go to our 10 a.m. which I know it's rather early.
I had a question for Audrey, but I got disconnected real quick. Is it possible to ask question, Chair?
Yes.
You can still ask.
Oh, okay. I'm so sorry.
You're
Thank
fine.
you, Mr. Chair. And thank you, Audrey. Audrey, we received a public comment about contact tracing. Is there any plans for us to coordinate with local jurisdictions on making that happen? I understand that's a separate process, but I guess is there any feedback or background on that?
So I'm wondering, we have a healthy exam plan that we have created and updated for every exam that we use, internally for us, for our staff, for the proctors who are working every exam site. And we are in the process of updating that plan and making sure we have the ability with where we have all the applicants seated, and to make sure that we can, if there is sort of like they do at my son's school, if we know of something, we know that someone had a positive case, we can let folks know who are in their vicinity that someone near them tested positive.
Okay. I might have not heard it, but are we requiring certain tests? And if so, is the state bar providing those to applicants?
So yeah, I went over the proof of entry for the exam, which is full vaccination or a negative COVID test. And we've put out all the information to applicants for several weeks about how they can provide that to us.
Okay, thank you so much. I appreciate it.
No problem. Thanks, Kareem.
Any other questions for Audrey? I don't see any. So I know that we are a little bit ahead of schedule as pertains to the 10 a.m. presentation. I was wondering if Mr. Efting is available and ready that we could go to his committee's goals, and that would be the operations and management approval of the report on the 2021-22 operations and management goals. Mr. Efting, are you available and prepared?
Yeah, I'm here.
Great.
The goals are set out on agenda item 0300. We're going to cover these in more detail. I want to do my slideshow later, but they're basically the same goals for the most part we've had in the past, is to consider appeals, to review the admissions or the reports on the examinations of the bar exam, to continue to work on guidelines for interpretation of the rules. We're going to discuss that in June. We're going to, again, look at the first year exam. What's interesting to me is we're working on, or starting to work on, this training video, which got put off because of COVID, but we're hoping to have some training videos about how to take the exam later this year in August, and we'll be talking about how that's going to go a little later on. And we want to review the examination fees, specifically the differential between the attorney's applicants and the law student applicants. So those are the goals. They're pretty much the same as before. Does anybody have any comments about the goals? If not, then I think, Sharon, could we have seek someone to make a motion?
So moved.
The movement would be to recommend the Committee of Bar Examiners approve the report of the 2021-22 operation management and operations goals set forth above.
So moved, Dolores.
Okay. Is there a second?
This is Mike. I'll second that.
Okay. So if appropriate, I'll ask Kim to do a roll.
Yes, thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Judge Herman,
Yes.
Mr. Iseri, Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Miss Lynn, Miss Pick,
Yes.
Mr. Rios,
Yes.
Judge Torriello,
Yes.
Mr. Torres. The motion passes.
Thank you, Ms. Wong. I'm not going to try to squeeze in another, so let's take a 5-minute break. That'll put us at about 9:58, and then we can start with the presentation at 10 a.m. So again, let's return in 5 minutes. Thank you, everyone. Okay, welcome back, everyone. We're going to continue with the open session, returning back to item D under the chair's time, a planning session, a discussion. This is going to be a great opportunity to see information that has been collected by staff as well as committee members among all the different subcommittees. So with that, I'm going to turn it over to Ms. Nunez.
Oh, I have the mic on. Great. Thank you, Alex. So on an annual basis, we dedicate time on the CBE agenda to review training sessions, goals accomplished from the previous year, in order to determine initiatives and goals and trainings that we want to undertake in the coming year. This is an opportunity for the committee to guide staff and propose ideas in these arenas. And this year, each of the program managers worked with the chairs of each of these functional areas to develop these summaries. And so what you're going to be presented with today is going to be led by each of the chairs of the subcommittee. And so with that, I want to hand it over to the first presentation, which will be examinations. So with that, I'll hand it over to Dr. Cow.
Thank you so much, Amy. And thank you for the committee to let me share with you the goals of the examination subcommittee. What we'll be talking about are the goals, the objectives, and the work plan for what we've done and what the upcoming year will be. So just to kind of refresh everyone, what are the functions of the examination subcommittee? Well, firstly, the CBE as an entity oversees the format, the scope, the topics, the content, and the grading process with the board's approval of the bar exam itself. The difference between the first year law student exam and the bar exam is that the CBE has the same delegated authority, but it also determines the pass score. In addition, the functions of the examination subcommittee is that it considers petitions, seeking waivers of the CBE's exam-related policies, procedures, and rules, and also has responsibility for reviewing the psychometric and bar exam reports. And then lastly, what we do is that we review appeals of staff decisions filed by applicants with disabilities requesting testing accommodations for taking the examination. So that's the function. Now, the changes that were implemented in 2021 for the exam development, just want to kind of go over with everyone, is that we try to identify ways in which diversity and conclusion principles can be institutionalized as part of the bar exam development. In addition to that, there was the development and delivery of enhanced training during the annual orientation of the new and existing EDGE team members and graders, which is the exam development and grading team. In addition to that, there's development of new subject matter matrices for each of the 13 subjects. And then lastly, development of pandemic-related processes and protocols for both the EDGE team and the performance team, drafting team meetings, pre-tests, which ensures confidentiality and security. So these were the changes that were implemented in 2021 for exam development. Now, what were the changes that were implemented in the exam grading for 2021? Well, try to be more efficient in monitoring and tracking grader performance through the exam cycle. There was an increased greater diversity because previously it was more localized when everything was in person, but now the graders were accepted throughout the entire state. There was developed grader selection rubric to eliminate potential bias in grader recruitment, as well as a decreased wait time for the results and the dissemination of essay answer files. So what are the anticipated changes in the examination development for 2022? Well, the first thing is that there's going to be a development of enhanced senior grader program. We're going to try to strengthen the apprentice EDGE team members training and skills development for assisting with exam development tasks. Number two, try to implement an annualized specialized training for all bar exam developers in subjects that are relevant to recognizing and addressing the potential bias question. Third, implementation of guiding principles in exam development to minimize potential bias in bar exam questions. Fourth, improvement of the State Bar's secure collaboration website to enhance electronic receipt and review of questions by the EDGE team and the drafting team, and to enable more efficient monitoring and tracking of question edits and drafts. And then lastly, to finalize and publication of the new subject matter matrices. So these are the anticipated changes for the exam development. And then what are the anticipated changes in 2022 for testing accommodations? Well, the first thing is we try to identify more efficiencies in case processing. Number two, improvement of applicant communications such as timeliness, messaging, accuracy, and consistency. Number three, streamlining application process. And then number four, review and revise admission rules relevant to testing accommodations, circulating for public comment, getting the review and approval by both the CBE and the Board of Trustees. And then lastly, additional training with staff and consultants. So the training topics for 2022 will include testing accommodations, presentation on substantive issues on evaluating TA petitions, training on testing accommodation processes, and then number two, examination development, presentation from examination development and grading EDGE team members on the basics of question editing. So these are the training topics. If there's any suggestions, please let myself and the staff know about what other additional training topics that everyone thinks would be valuable for 2022. Now, what are our current goals? Our current goals for examination development. Well, first, we've heard Amy discuss about the Blue Ribbon Commission. So we have to monitor the work of the Blue Ribbon Commission on the future of the California bar exam, as well as look at the NCBE's implementation timeline for the next generation of the bar exam. So that's for exam development. And then for examination grading, we need to evaluate the grading guidelines to address procedure for reconsideration requests, for test center incidents and examination results. And then lastly, examination development and examination grading. We need to work with the State Bar's Office of Access and Inclusion, as well as fairness, to develop a process and procedures in examination development and grading that can advance the mission of the State Bar to support efforts of greater access to and inclusion in the legal system. So those are the current goals. So what are the recommendations for the work plan? Well, goal number 4, which is under the strategic plan and objective, which is to identify ways that diversity and conclusion principles can be institutionalized in bar exam development and grading in regards to analysis with final proposals, formal guidelines or rules. So the work plan is actually to approve and implement guiding principles in the exam development to minimize bias in the bar exam questions. The deadline for that will be in the spring of May of 2022. And then the other goal will be to improve productivity through performance, accountability, training, and professional development. So what's the work plan for that? It's to review the admissions rules relevant for testing accommodations, to revise forms and materials aimed at gaining efficiencies that will improve productivity. And then lastly, which I think is very valuable, is to have an ADA expert to train our staff as well as our committee on improving methods for reviewing accommodation requests. And this is going to be an ongoing process. So these are the recommendations for the work plan. So this concludes the examinations section. Are there any questions? Amy, are there any questions? Or if not, I'll turn it back over to you.
Yeah, one thing is maybe we should open it up, Dr. Cow, to see in terms of the proposed training sessions, if there's any additions or thoughts about what's on that. And maybe it's like, I think 2 screens back. Training topics for 2022. This is in the areas of testing, accommodation, exam development. The idea is that's proposed here is a presentation from the EDGE team on the basics of question editing. And then also for TA, substantive issues on evaluating TA petitions and training on the TA process. But any other thoughts or suggestions? This is a unique opportunity where we could revise our goals, and that would include trainings and initiatives that we're taking on in these arenas. Any other training topic suggestions?
Amy and Dr. Cal, maybe just a question, not so much additional topics, but any thoughts about sort of when the delivery of these training sessions might be over the course of this year?
I think that we're going to go over that in the section that talks about the reports, right, Amy? On the reports in agenda item 0203.
Okay. Thank you.
Perfect. All right.
Amy, maybe I just missed it, but there's talk of hiring a new staff manager who's going to be more perhaps substitute for some of the outside experts that we've been using for the accommodation appeals. How's that going?
Paul, we're gonna talk a little bit more about that later on in the agenda, but yes, we have an update. And so our idea is to provide an ADA expert consultant. And in the meanwhile, also, we have Christina Dole, who will be taking on the program manager role for examinations, which includes oversight of the testing accommodations unit and the grading. She will continue working on that. And so, and what that means is Lisa will be dedicating her time to exam development. So yes, so and we'll get into more detail later on in this agenda. Okay. So then if we're done with examinations and there are no more comments, then we could move on to the next, which is a presentation on O&M. And I believe this is Mr. Efting.
Yep, let me get myself here. Okay, hi, everybody. Okay, so this is Operations and Management Subcommittee, and Tammy Campbell is our program manager. And why don't we go to the next slide if we can. So again, the purpose of the Subcommittee on Operations and Management is to review and revise the rules and policies for examinations, refunds and violation examination rules, what we call Chapter 6 violations as needed, and directed by the whole committee. We conduct administrative appeals of examination petitions on request for applicants who denied from the staff. So if there's an issue with respect to examination, pretty much we're the committee who, after the examination has taken place, we're the committee who looks at that. Next slide. Oh, sorry. Yours slide's a little different than mine. So we implemented a number of changes in 2021. The big one, of course, was we expanded the provisional licensing program to include individuals who scored 1390 or higher on a California bar exam administered between July 2015 and February 2022. But what's important here is the program sunsets on June 1st, 2022. If you have questions about what that means, we can talk to Tammy about that later. But that program does sunset in June 1st, 2022, unless there's some changes to it. We continue to work on improvements for the AIMS program. And again, due to the COVID-19 pandemic, we continue to administer the first year exam and the California bar exam remotely. That's in 2021. So this is what happened in 2021. We go to the next slide, we look at what's anticipated for 2022. And we continue to try to identify efficient ways to proceed with matters. Important is to strive to improve applicant communication, which is, I think, important to all of us, including timeliness, messages, accuracy, and consistently getting back to the applicants with answers as quickly as possible. We also want to streamline the application process, and we'll talk about that a little more later. subject to a review and approval by both this committee and the Board of Trustees. Again, to continue to review and revise admission rules relative to eligibility, special administration, and exam administration. Want to circulate that for public comment and then submit for review and approval by the Committee of Bar Examiners. Moving on to the next slide, the February 2022 committee bar exam is going to be done in person, which I think we've heard before and know. The new one here, which we might not be aware of, is we're going to hire a new organization called PSI Online to support the proctor recruitment program and to provide us proctors. And then I have a question for Tammy at this point in time. Item number 2 indicates that the PSI Online will actually take over site acquisition. So I presume what that means is that starting in July, rather than our staff coming up with the different locations for the exam, that the PSI will take over decision of where the exams are take place. Is that correct, Tammy?
That is correct. They will be the ones to start securing all of our facilities. And of course, we'll continue to use the same facilities that we've used previously, but they will be the ones to take over that process and make sure that the exam is ready to go for us when we arrive on site.
So they'll make the contracts with the electric providers and all the other people that basically we used in the exam. Okay.
Yes.
As mentioned before, the provisional licensing program is scheduled to sunset in June of 2022. And things that we're working on is to study and consider amendments to California Rule 9.42, authorizing law office students to participate in practical training of the law student program. So those are things we're working on in 2022. On the next slide, recommendation for work plan. Okay, sorry. Again, a couple of goals here. One important goal I think is very important is greater transparency, accountability, efficiency, and access. I think several public comments indicated continuing concerns about that. And we want to continue to improve, review, and make recommendations with respect to the applicant facing side of the admission information management system. Basically what the applicant sees when it goes online to look at applying for admission. I think that's important for us. And then again, to review admission rules relative to eligibility, special administration, and exam administration, to again work for greater transparency, accountability, efficiency, and access. And I think we want to hear from the public.
Mr. Epting, can I
Sure.
just interrupt? If maybe we can advance the slide to show the work plan.
Oh, I'm sorry. I thought we did. Okay. Thank you, Alex.
Mhm.
Okay, so again, I've gone to the first one here, goal 2, bullet points. The second bullet point, again, important is facilitate greater transparency, accountability, efficiency, and access. And wanted to hear from the public so we can make sure we meet those goals. Second goal is, our third goal listed here is to improve productivity through performance accountability, training, and professional development. And again, continue to work with the Ames program to continue to get better reports, find out what's going on, and how to assist the applicants. And again, we want to provide professional development and opportunities for staff. So in the final slide, I believe, is the current goals for 2021 and 22. Do we not have that? Anyway, we just.
Here it is.
Okay, thank you. And again, we talked goals a little earlier my earlier presentation, but again, we want to continue to consider appeals, seeking waivers of committee's examination policy, procedures, and rules, which we bring before the committee each month. Continue to review reports on the administration of the bar exam. We'll be doing that again in April and in October of this year. We want to consider proposed guidelines for interpreting the admission rules, such as areas of eligibility and admissions. We'll be doing that in June. Again, in this meeting today, I think we're actually going to review the administration of the first year law student bar exam, which we'll do again in August. We kind of continue to work on the production of the training video, which we talked about earlier. And lastly, we want to again look at examination fees. These are kind of the same goals I laid out earlier. So that's my report. If anybody's got any questions or comments, I'd appreciate them.
Jim, I have a comment.
Sure.
And this is a comment related to the review of examination fees. In terms of the timing, I think we will need to do that a lot sooner than August 2022. As we're preparing our admissions budget in the coming year, we are going into this budget in a deficit with about a $9 million deficit. Right now, what we do know is $5 million of that is structural. And so what we have is to review the budget with the mind of what the cost is for this exam. And so as part of this review of potential cost savings in our in the Office of Admissions, right, as we progress with this. So in the coming year, we have a healthy reserve balance that will help us offset this $9 million, but it's not something that we could sustain in future years. We're also concerned with raising exam fees. And so what the goal of this next year is, or in the next few months, is to really dig down at examination fees. I know that this committee has seen financial reports in the past related to bar exam costs. And one caveat to those reports is we've never really added on some of the fees that other costs that are associated with the exam, such as staffing, which is a big component, as well as consultants that we use. We have a TA, our TA consultants. We use consultants, for example, epidemiologists that have worked with us. And so all this to say that we need to expedite this sooner. And I just want to highlight that to this group before we, as we embark on this deficit budget, we look for potential solutions on how to address that in future administrations of the exam and for the future of the admissions budget in fiscal year 2022 as well as 2023.
Amy,
Yes.
what about the fees for law schools? I have heard speculation that they may not cover all of the costs of providing the basic law school regulation services. So I'm wondering if we shouldn't look at those as well. I would hate to see that bar exam takers are in some way subsidizing the law schools. I don't think that's, at least it's a policy decision we should consciously make. I'm not sure we can, but I'm at least initially not in favor of that being the case. So are we going to look at those as well?
Yes, we are. I think at the moment, our priorities are the bar exam fees and moral character. And, the intent is also not to offset costs, or to identify other ways of offsetting costs. If there's a way that we could eliminate the need to increase our fees, that's what we're trying to explore. And so, so that's a priority at the moment. But yeah, I think eventually we're going to have to review what the actual cost is, as you suggested, along with law schools as part of that as well.
Oh, it would just seem to me that maybe that's a more immediate need if there is pressure on your reserve funds.
Yeah, we could definitely add that to the two that we're looking at, the two areas that we're looking at now. Any other thoughts on the goals? Okay, all right, thank you.
Thank you, Amy. So I think I'll go back to Alex then, right?
Okay, this is me, Vince. We're good, Amy, to go?
Yes, we are.
Yes,
Sorry
Vince.
about that. So,
Okay.
yes, thank you, Vince.
Okay, good morning. This is a subcommittee on moral character determinations, and our program manager is Tara. And Tara, I'd like to thank you and David and the staff for all your insights and for shepherding this plan through. Just to reiterate our function, next slide, we're the oversight and administration for all moral character determinations. So in the course of that, we conduct administrative reviews for the applicants who've received adverse determinations from the staff. Okay, next slide, please. So this is what we did last year. We increased our outreach to the OCTC. In fact, participated in a state bar day with OCTC and the LAP, and also the Attorney Regulations and Consumer Resources. So it's just a ways to get more awareness and education out about moral character. We've continued to coordinate with Ames in terms of making our systems a lot more streamlined. And then we began the review of the state bar admissions rules that correspond with moral character. Okay, next slide, please. So the changes that we're looking at for this coming year are mainly a smoother process in terms of processing the cases. A lot of this involves better communication with the applicants, timing, how we communicate with them in terms of our messaging, our accuracy and consistency. So it's pretty much keeping everything transparent as much as we can. This year, we're also going to look at the actual application for determining for the determination of moral character, and to look at the substantive changes that have been proposed and then review them and get the approval of the CBE and also the Supreme Court. Lastly, we need to look at the revision of the rules that are relevant to moral character, and again, match these up with the admissions rules, and then also get those reviewed by the CBE, the Board of Trustees, and the Supreme Court. So we're looking for feedback at all levels to make sure that we have rules that are aligned with the admissions. Okay, so the training topics. This is important to the committee because it's not only the subcommittee that makes and votes on the decisions regarding moral character and adverse decisions, but or recommendations, but the entire committee has to vote on these. And so these are kind of refreshers for everybody, or an introduction to what some of these are. So we've already had some of these trainings, and I'll go over that in the next slide. So we've already completed, as of last month, the post-traumatic stress disorder training. We're going to be looking at bias in moral character. We're going to be looking at more relevant court cases so we can apply those lessons to our decisions. And then we're going to keep having trainings on ethics school and trust accounting so that we can better determine what's actually the content when we send somebody to ethics school or trust accounting. We will, again, as we've mentioned before, look at the rules that are relevant to moral character determinations, receive ongoing training as I've discussed. And then also ongoing is just conducting the administrative reviews. Okay, next goal. So goal 3 in the strategic plan, much of this is improving in performance. And again, this is aligning ourselves and taking advantage of Ames, having full accountability with Ames, more training around Ames and how we can utilize it, and to provide more professional development opportunities for the staff. Okay, so are there any questions?
I don't see any, Vince.
Okay,
Thank you, Vince.
thank you.
All right,
Dudley.
and now- Oh, sorry about that. Alex.
No, go ahead.
Now we're moving on to ed standards, and I believe Mr. Paul Kramer will be presenting on that.
And this is Natalie Leonard, and I'll be supporting Paul and encouraging Paul to jump in anywhere he likes as to the educational standards portion, but I'll get things going. Next slide, please. So just a reminder, California is unique in its structure of law schools. In addition to the ABA approved law schools, there are also CBE accredited law schools that have been with the committee since 1927, as well as unaccredited law schools offering 52 different legal education options in California, in addition to the law office study program. Next slide, please. The educational standards functions, including registering as unaccredited or accrediting qualifying law schools, monitoring those schools for compliance, evaluating change requests along the way, and fostering active law school engagement through a number of avenues, including the Committee on State Bar Accredited and Registered Schools, composed of deans from both the unaccredited and accredited school types, as well as CBE members. And I'd like to thank Paul Kramer for his service on the commission both this year and last year. The Law School Council, which is composed of ABA approved law school administrators, the Law School Assembly, a large group of all of the California law schools, registrars meeting, again, all of the California law schools, a State Bar Day focused towards students, and a quarterly Dean's e-newsletter, which has been expanded to really take on more of a role of an administrator's e-newsletter. And in particular, those in the bar prep area have appreciated having the expanded distribution. Next slide, please. So just quickly, a reminder that the ABA approved schools are fully regulated by the ABA. They are deemed accredited in California. And so that's handled out of the Council of the Section of Legal Education and Admissions to the Bar at the American Bar Association in Chicago. The State Bar regulates both the registered and unaccredited schools. The registered schools have 3 school types: fixed facility, correspondence, distance, and they are only part-time programs. They're actually restricted from a full-time program. The California accredited schools have more standards, but also more flexibility. They can teach in a mixed format, full and part-time programs. The committee doesn't directly regulate the law office study program, but that is another pathway to legal practice in California. Next slide. Our Law School Council is 7 ABA deans or administrators. That group meets several times per year. They will next meet in April. When they meet, it's a public avenue, and anyone can view the webcast online. They will meet again on April 20. The Committee on State Bar Accredited and Registered Schools has been meeting on the Wednesday prior to the committee meeting, composed of 3 CALS deans, including the chair, Jay Frickberg, who you'll hear from a little bit later today. 2 registered unaccredited law school deans, and our CBE appointees of Greg Murphy, an experienced member of the prior ABA Council, as well as Paul. This year, we are also doing a lot of collaboration with the Office of Access and Inclusion on focus groups related to improving law school retention. There's been very high participation in these groups. There have been 3 groups so far. There'll be 1 more on February 1st on the final areas of retention, and we're very excited to see what the findings are from those focus groups and that survey. Next slide, please. CS Bars provides feedback and recommendations as requested by the CBE and the State Bar. We hope that that advisory support is very helpful to this body in making decisions. The group worked very hard in this past year, always so, but in creating and implement a recommendation that allowed you to implement a fully new set of rules for accredited law schools. They also suggest topics appropriate for ad hoc working groups and help to find members to participate in those working groups to propose to you. and suggest topics for the law school engagement vehicles that we mentioned earlier. Next slide. Law School Council, very similar, but from an angle of ABA approved schools. So it's very nice for each of those groups to have their own forum. I know that they very much appreciated that, and we occasionally do bring them together as we did in December. Next slide. In 2021 was a very busy year for educational standards. The new rules for accredited law schools were adopted. They are effective as of January 1st, and you will see them being phased in at the law schools over the next 2 years, but many of the law schools have been planning for this for a long time and are very close to compliance already. Also, as soon as the rules were created, they needed to be updated to update the minimum pass rate standards for accredited law schools to account for the provisional licensure program. So that was completed after several rounds of public comment, and it was ready to go when the law school rules were implemented. The pandemic general waiver completed. This committee acted very quickly at the start of the pandemic to give the schools the flexibility they needed to address the students at the various life stages at the schools. Many of the students in the unaccredited and accredited schools may be mid-career learners, taking care of parents at home, raising families, working day jobs. And so it was very helpful to them to have the general pandemic waiver during the height. And now many of those schools requested individual waivers if they wanted to continue online learning. Continued to expand demographic data collection. Each year, for the last 2 years and this upcoming 3rd year, we're collecting more information about the folks who are attending the unaccredited and accredited law schools, as well as who completes and who does not complete and why. So that will help us to provide more support and guidance and better monitor compliance in the future. Started the State Bar Law Day for law students. It's been very popular. When the registration is put out, generally within a week, all of the spots fill up, and we'll be expanding the size of that State Bar Law Day so that more students can participate. There's also an option for schools to request a custom presentation, and several schools have done so. And I'd like to thank Lisa Cummins and Tara Clark in particular, who helped to put those custom presentations together, along with the lawyer assistance program. We also added an interactive applicant portal demonstration to the registrar's meeting. We hadn't done something like that before. There was a lot of interest, and we got many excellent suggestions about the portal, how students use it, and how they might use it more effectively in the future. We partnered with the National LGBTQ Bar Association to have them survey the unaccredited and accredited law schools with their campus climate survey to learn about how LGBTQ plus students can access the registered and accredited schools. And we continued to foster the focus groups on law school retention. Next slide, please. For the most part, we will be continuing many of these initiatives, which are large multi-years initiatives, including implementing the rules, issuing the new applications and periodic compliance reports that go along with those rules, beginning a review of the rules for unaccredited law schools, as well as the demographic data expansion and access and inclusion focus groups that I mentioned earlier. We also will be monitoring the conditions as law schools transition back to classroom teaching, or whatever education will look like as we emerge from the pandemic. Next slide, please. In terms of training, we will continue to update you on what we learned from the law school engagement. And we also plan to bring a regional or national accreditor to come to speak to this body to help you get ready for the jointly accredited status that is part of the new rules, allowing the accredited schools that are also accredited by either a national or regional accreditor to satisfy some of their requirements through the monitoring functions of those accreditors. We think that that will streamline the process, potentially reduce costs for the law schools, and we're very excited to implement that program. Next slide. In terms of the goals, I really went through some of these a little bit earlier. It's just really recapping what we've got so far. We'll also continue to pursue mandatory accreditation for unaccredited law schools. As we do the communication for the accredited law schools, we will be including the unaccredited law schools in those communications so that they are very aware of what the accreditation requirements are, and encouraging them through distribution of that information, but also talking with them at their inspection reports about what the requirements are to encourage them to move ahead to that status and take the steps they need to do it. Are there any other questions or suggestions about the goals or the training? Okay, next slide, please. Finally, in the work plan, it's really just codifying the things that we talked about as to when they might be happening. And you might see a goal date there, December 2020. That is a date that is there on purpose. That explains when we originally created the plan to expand demographic data, and it's just a 3-year rollout in order for the schools to begin collecting it. So they have to advise the students that it's coming, collect it over the course of the school year, and then report it at the end of their compliance year. So that was the PIN that started the program, and it's been continuing and will complete the expansion in 2022. So that's everything we have for educational standards. I'd be happy to entertain any questions, and to thank Paul in particular for incredible support, incredible leadership, and attention to detail in this very important area. Okay, thank you.
Thanks, Natalie.
Thank you, Ms. Leonard. Thank you, Mr. Kramer. Thanks to all the staff that supported putting this together, as well as all the chairs of the different sub committees. But before we move on, or any other comments or questions from the committee members before we return back to the open agenda items? Looking at the Zoom, I see some head shaking. No, so
Donna has her hand up.
oh, yes, Donna.
Yes, thank you. I appreciate you calling on me. I just wanted to mention, I'm not sure if you all were noticing a bit of a trend in some of the work that's planned for 2022. And there was one specifically around Ames related issues and making improvements to Ames, as well as review of and revision of the rules that relate to many of the areas, operations and management, examinations, et cetera. And the reason for that, as part of the Board of Trustees strategic planning exercise, we met with staff in all of the offices around the bar, and we asked them, what do you think that the state bar should be focusing on in the next 5 years? And as we met with admission staff, and we actually broke admission staff up into a number of small groups, I think maybe 6 or 7 small breakout sessions, and we talked to folks, and uniformly all of the groups came back and talked about things that could be done. They had some really fabulous ideas, things that could be done to make Ames a better system for the applicants, ways that there could be better dashboards, there could be better instructions, better information. So applicants felt, understood what their obligations were better, and didn't feel the need to make a call to the Office of Admissions and create the more people who are calling because of the system, if the system is confusing, then the longer it takes to return those calls. And so really to streamline the processes, make it better self-service for Ames. Also uniformly, the admission staff talked about some of the confusion that they hear. People tend to have confusion about X issue or Y issue, and the rules we think are unclear, and the rules could be made clear. Here are areas that the rules don't touch, and we have to that come up as areas of first impression. And so hearing this, these were things that at a staff level, we said, okay, this is great. Like we need to work really closely with all of the staff and engage on these issues and what can be done across the organization to make things better for those people who are interfacing with us and those people who are interfacing with the system, to make it clearer, to give them more information, to provide instructions, to explain terminology that makes perfect sense to us, but not to people who don't live in our world. And that's where some of the themes that you saw in all of the areas came from. And I just wanted to point that out because I thought to me, it really jumped out, sort of the noticeable themes, the through line that was going through all of the proposals for the next year.
Great, thanks, Donna. That's really helpful. So I don't see any other hands raised or any questions or any other comments. So as we go back to the next item on our agenda, the examinations, and we have a special training, or we have a training set for at 2 p.m. However, I'd like to move on to item B, approval of the technical report on the October 2021 first year law students examination with Dr. Cal and Ms. Dole.
Yes, thank you, Alex. So Christina Doe is our program manager, and I wanted to thank her for putting that presentation together. What we'll be talking about today is agenda item 0200, which is the approval of the technical report on the October 2021 first year law students examination. The report was prepared by Roger Bolus on the October 2021 administration of the first year law students examination. So it's recommended that the technical report be approved, received, and filed. Can we have a motion on that?
Is there a motion from the group?
So move. This is Kareem.
I'll second. This is Vince.
Thank you. And the proposed motion is that the committee of the bar examiners agree with the staff recommendations. Following the motion would be that the technical report on the October 2021 first year law students examination dated December 28th, which was prepared by Roger Bolus, be approved and therefore received and filed.
Thank you. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Cow?
Yes.
Mr. Chen? Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger? Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan? Mr. Kramer?
Yes.
Ms. Lynn? Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres? The motion passes.
The next item on the agenda is agenda item O-201. And that agenda item is that it's recommended that the Committee of Bar Examiners approve the report to be finalized and transmitted to the Supreme Court. This was the draft report submitted about the statistics, about the composition of the 2021 bar examination takers and passers. The technical analysis was prepared by the committee's psychometrician, Dr. Bolus, as well as test questions and selected answers. Can we have a motion for that agenda item?
So move. This is Kareem.
Thank you, Kareem.
Michael Siri, second.
Thank you, Michael. So the proposed motion would be if the committee agrees with the staff recommendation, the following motion is suggested that the draft Supreme Court report on the July 2021 California bar examination be finalized and submitted to the court.
Thank you, Dr. Cow. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Cow?
Yes.
Mr. Chen? Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger? Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer. Mr. Kramer. Ms. Lynn. Ms. Pick?
Sorry, yes.
Okay, thank you. Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Torrealba,
Yes.
Mr. Torres. The motion passes.
Thank you. The next on the agenda is agenda item 0202, the approval of the guiding principles in examination development to minimize potential bias in bar exam questions. I'm going to turn that over to Bethany Peak, Michael Seri, and Alex Chan for that one.
I believe that Michael is presenting.
Yes. Just pulling up my notes. Hold on a quick second. Awesome. If I'm looking at this way, I'm looking at my larger monitor for easier reading, so I apologize. In 2019, the State Bar contracted the Scantron Corporation to conduct a differential item functioning, also known as DIF, analysis for essay and performance test questions administered on the California bar exam between 2009 and 2019. The DIF working group held public meetings in 2020, specifically in December 18th, and 3 more meetings in 2021 on April 14, October 19, and November 29th. In addition, we met another time for quick approval of everything this year, 2022, January 12th. In between April 2021 and October 2021 meetings, we as individuals were given an exercise to review the same 20 past bar exam questions, which consisted of 18 essay questions and 2 PTs, selected randomly from the DIF study by the State Bar Office of Research and Institutional Accountability, or what they call it, the ORIA staff, as having highest and lowest DIF flags, 10 each, or roughly. Subgroup members were asked to analyze all 20 questions for potential biases in the 7 dimensions described below, which I will get to, and thereafter to meet with staff to disclose the findings. Results were received from 7 members, generating around 980 data points to learn from the exercise. That's roughly broken down to 20 questions times 7 times 7. When DIF is identified in a specific question, the information helps to identify potential issues in the question. DIF is not synonymous with bias, and the presence of DIF in a test question does not necessarily mean a question is biased. No statistic can determine whether or not a question is biased. Ultimately, it is a means to help ensure the fairness of tests. Just to unpack that, it's essentially, it helps us form a better and more, you can say, a fair question. Essentially, we're trying to eliminate as many preconceived notions, allusions to bad stereotyping or bad use of, say, technical and item terminology that different age groups or different background groups may or may not have that much experience. Most relatably will be the SATs on some of the analysis, but that's back long ago and I wasn't on SATs. I just heard it from my high school experience of just how they had some issues with it. Coming back to our purpose with the DIF group. The purpose of the analysis was to examine DIF on the CBX essay and performance test items with respect to the following demographic variables: gender, race and ethnicity, and law school type. Secondary variables such as item type, subject matter, and administration window were also considered in the analysis. The report was presented to the CBE at its April 2020 meeting and to the board at its May 2020 meeting. The results of the DIF study indicated no major areas of concern for the CBX with respect to DIF. Only 5% of the items were flagged in the race ethnicity analysis based on the Caucasian / non-Caucasian analysis, which is a small amount of the DIF for an assessment. Although a large proportion of items were identified for law school type DIF, those findings were not unexpected, given that applicants at different law school types have different educational backgrounds. The 7 areas that I mentioned earlier that we looked at are the following, and I can break them down, which I'll just break down as I list them off. 1, gender bias. Does the exam question contain any language or concept suggesting any gender bias? 2, cultural bias. Does the exam question contain any language or concept suggesting any cultural bias with culture broadly defined? Offensive, which is the 3rd category. Does the exam questions contain any language or concept that may be found offensive for any reason? I should know that's rather broad, but that's just, it's one of those you just kind of have to see it. Or other categories may encompass that. 4, perpetuating stereotypes. Does the exam question contain any language or concept that may be perceived as perpetuating certain stereotypes? 5, unfair representation of certain groups. Does the exam question contain any language or concept that appear to represent certain groups unfairly? I think for that one, in my personal experience, it could be based on also cultural biases in terms of economic disparities. Number 6, construct irrelevant knowledge required. Does the exam question in language use or how the issue are presented appears to require applicants to be knowledgeable in certain areas that are irrelevant for the main issue in the question to be answered with competence. That's roughly will be, I think a example we looked at was surfboards, the terminology on surfers or something like that, which that kind of is irrelevant knowledge. I think it might be a waxing the surfboard or something similar to that with surfboards. Outside knowledge on how to surf or something may have assisted, but that's I'm just recollecting a question related to that. Now, the last one is number 7, language that put any group at an advantage. Does the exam question contain any language that may put certain groups at an advantage or disadvantage? And again, that's very similar to terminology, item usage, and does probably economic in some societal backgrounds. For example, if you are economically rich, you may be more favorable to do certain sports such as lacrosse, and the terminology use that. I'm just pulling that as a random example. Not something that I think we looked at all during the DIF analysis of the bar exam. Most of the language and individual questions flagged by the working group members as raising concern were relatively subtle. No racially inappropriate or otherwise overtly biased terminology was found. The first 10 bullet points in the attachment document, if you look at it, are to serve as guidance in CBX question development and will be provided to all developers of the CBX, including question drafters and pre-testers, the examination development and grading, the EDGE team, and the performance test, PT, drafting team. The guidelines refer to the content of exam questions and what should be done and what should be avoided to minimize potential bias. As such, the guidelines will also be part of what CBX considers during the question selection process. The last 4 bullet points describe the annual training exam developers should receive, the goals for question developers recruitment practices, and recommendations to the CBE for further review development of its question developer and pre-tester recruitment processes so as to advance diversity and inclusion in the pool to ensure varied perspectives, backgrounds, and experiences, while also maintaining the necessary level of examination development, grading, and pre-testing skills and expertise. Based on all that, it is recommended as the following. It is recommended that the guiding principles in examination development to minimize potential bias in bar exam questions developed by the DIF working group be approved, then sent to the Board of Trustees with a recommendation for approval. The fiscal personal impact is none. So with that, I propose the motion. Are there any questions before I propose, I guess? Hearing no questions.
Michael, I have a
sorry.
question, more like a comment.
Sure.
I just want to commend the committee's work on this, because I think it's gone beyond just scratching the surface. There are so many instances of professional licensure over decades that show a lot of cultural bias or class bias and race bias and things like that. And so I think the work that was done here, you're talking about 20 questions and you're coming up with certain guidelines and looking at it. I just want to repeat that it more than scratches the surface to try to bring some recognition that exams really need to be looked at for these kinds of biases. And I think it's also important to understand, and I'm sure that these things came up during the discussions, that it's important to understand why these biases are there in the first place. It's not just because somebody looks different or they came from a different country, but there are a lot more fundamental reasons why things like racism and prejudice and things like that exist in society. So I think that this kind of exercise contributes to a more critical thinking process of how these exams should go forward. And this is my own bias. There's a pretty big movement out there to kind of deny the existence of any sort of, let's look at prejudice for what it is. Let's look at racism or class for what it is. So I think that this committee taking the responsibility to delve a lot further says a lot about how we care about questions of equity when it comes to testing. So with that, I can support moving this motion.
And thank you so much for that, Mr. Reyes. I hearken and definitely approve what you said personally. I think my main takeaway from working on this amazing group as well, and it was quite a bit because we kept on, I think we received 2 or 3 cycles of training questions that we had to do analysis, and trying to meet at ad hoc times during the pandemic of when can we go over each for our little subgroups and then come back. I think the main takeaway from me, and I'm sure if other members want to chime in, is ultimately do not be storytellers when asking questions. I think when us as being attorneys, we love to exaggerate or use more specific details in our storytelling processes that is reflective in the questions. It may be true and relevant in real world application. However, in real world application, you will have the time and a Google search engine to actually look up any interesting terminology or practices. Under the test exam environment, I think we need to refrain from storytelling and just simply ask simplified questions. I think the best example was highlighted in my group was the term of an SUV for a car-related personal injury question. We should replace the SUV with a car because it doesn't change the meaning or connotation of anything. Some people may not know what an SUV is. For me, that sounds a little odd. However, I have to, understand that other people may call it differently. And then I think Mr. Gongoro mentioned something previously that, yeah, based on his experience, they don't use SFE in different cultures. It's just call it differently. But it's that subtle moments of trying to make the connection or linkage when trying to express common knowledge on common practices. That small delay of trying to correlate or unpack stuff, it's unfair. And that's why I'm hoping that from moving forward, I mean, we've been doing, what I've seen is we've been doing a good, decent job, and there hasn't been major indications of that. I'm hoping that moving forward, we can actually just beyond improve what we already are doing. Are there any other comments or anything before I make the proposed motion?
I have a comment real quick, Michael, if I may. I just want to thank you for your work. Thank you for your presentation. I know this stuff gets very technical and wonky, but just want to appreciate the time you devoted to this, and I'm really appreciative of it, and I'm in favor of it.
I mean, everybody, thank you, and everybody else has been tremendously wonderful working with during the diff group. And I have to really, truly give applause to all the staff, to all of our members here who partake, and to, I believe, the Access and Fairness Council, I believe, who was part of it early on, if I recall correctly. No, thank you for that. Any other comments? I'm trying to see if there's any raised hands. So just,
I have my hand raised.
sorry.
No, I'm just trying to make sure I get heard. Thank you, Michael. Thank you so much for the presentation. That was like super thorough. And, you know, also co-signing what you said about the staff, like Lisa and her team obviously did a great job. This is very, very important work, like Vince was pointing out. And so I did just want to thank Lisa and all of her team and everybody else, because this was a lot and we've been doing it for several months and it's extremely important. And I just wanted to, this is just a comment, I wanted to raise one point, because I had raised this early, like in our first meeting, I think in the diff meetings, but we're the committee that I think it's more appropriate for. And so I think that we should, along with, you know, having the diff guidelines and all that we're going to work on, our efforts to improve the diversity of the committee, not the committee, but the group that actually selects the questions that we then do our review for. I think that that is another important aspect of this analysis that we're doing. And Lisa had explained, you know, like how we're sourcing people, the attorneys that are picking the questions, that kind of has led to the reality that it's an entirely all white group. And so I think that as we're moving forward, that whatever efforts we can do as a committee to try to ensure that there's some diversity in ethnicity and gender and age on that group, that would really be beneficial to this diff work. And I think just to the work that we're doing for the bar overall. But again, thank you, Lisa. Thank you, Michael, for the wonderful presentation.
Thank you. And with that, again, you can see the attachment. It's the final 2 pages of our recommendation. I can do the proposed motion now, or if you want to just.
Sorry, Michael, I believe somebody had made the initial motion, right?
Yeah, I'll make the motion. This is Vince.
This is Bethany, I'll second.
Thank you. Michael, would you like to read the proposed motion?
Sure. Proposed motion set forth. Shall the committee of bar examiners agree with the staff recommendation? The following motion will be appropriate. Move that the guiding principles in examination development to minimize potential bias in the bar exam questions developed by the diff working group be approved and submitted to the Board of Trustees with a recommendation for approval.
Thank you. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Kao?
Yes.
Mr. Chen? Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba? Mr. Torres,
Yes.
the motion passes.
Michael, thank you so much for that wonderful presentation, and for the group working on that. Thank you so much. We're just going to continue with the next agenda item.
Sorry, could I just say this is Judge Toriyama? I'm sorry, I couldn't unmute quickly enough, and I vote yes and concur with everything that everybody said.
Thank you, Judge Toriyama.
Thank you, Judge. So I want to proceed with the next agenda item, 0203, which is the approval for the report on the 2022 examination goals. And this may answer the previous question that our chair, Alex Lawrence, had. So the goals are listed, as what's seen. I just did want to highlight that the training, which was alluded to, for the subject matter will be on the principles of scaling written test scores on the California Bar Examination to the MBE. And then the additional training we're also going to be having is subject matter on substantive issues in determining accessibility and disability for purposes of testing accommodations. Otherwise, they're similar to what our previous examination goals were as well too. So can I have a motion on that?
This is Robbie Brody. I'll move to adopt the goals.
Thank you, Robbie.
And who makes the who second?
Michael is a second.
Thank you.
Thank you, Michael. So the proposed motion would be, it is recommended, proposed motion should be that the Committee of Bar Examiners agrees with the staff recommendation. The following motion should be made. Move that the report on the 2022 examination subcommittee goals be approved.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Kao,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Yes, yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriyama,
Yes.
Mr. Torres,
Yes.
the motion passes.
Thank you, Ms. Vaughn. Thank you, Dr. Kao and committee members. The next item on our agenda, we have already completed O&M. So we're moving on to Ed Standards with Mr. Kramer and Ms. Leonard.
Okay, thank you. First item is 0400. It's a major change petition. Irvine University College of Law is requesting approval of a name change to Irvine College of Law, in part to avoid the possibility of name confusion with the UC Irvine Law School. Staff recommends its approval. There's one change to the proposed motion, however. We received a public comment earlier in the week from Dean Leal, and he wants this to be effective June 1st, which would correspond with the start of their new semester or quarter, and also their change of their school to online education that we previously approved. And that's a change from the existing February 1st that's in the motion in the materials that were distributed. Any questions, or does somebody wish to make the motion?
So moved. Second.
I'm sorry, who made the motion?
Torres.
David Torres, Kareem seconded.
Thank you, Kareem.
And I'll ask Audrey to advance to the next slide, the A version that has the date that's requested by the school. Was not originally requested in their petition, but it was provided via update. Thank you.
Kim,
sorry.
go ahead.
Okay, Dr. Bolton,
Yes.
and Dr. Brody,
Yes.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger, Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Rios,
Yes.
Judge Toriaba,
Yes.
Should hide that from P.
Mr. Torres.
Yes.
1:30.
The motion passes.
There we go.
No, cream.
Okay, next is 0401. That's the action on San Francisco International University School of Law's response to our previously issued warning letter. And actually, it's a lack of response. They have not responded in any way to our warning letter. It was sent to several different addresses we had for them. Therefore, it's appropriate to continue the compliance process by issuing a notice of non-compliance. Staff indicates that indications are that the school has just closed and basically shuttered and disappeared, but we still have to go through our process of giving them notice, various notices before we can terminate them if that becomes necessary. So that's what this action would do. You want to put up the motion, Natalie?
Yes, please.
Any questions? If not, a motion?
This is Kareem, so move.
This is Vince, I'll second.
Thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cobb,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Rios,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
the motion passes.
Thank you. Next item is C, 0-402. Action on continuation of 2009 waiver of unaccredited guideline 1.11 regarding credit for exam preparation courses at unaccredited law schools. Guideline 1.11 prohibited giving credit for first year and general bar exam preparation courses at the registered unaccredited law schools. In 2009, our committee approved a waiver allowing them to give credit for those courses. The language of the waiver implied that the committee intended to incorporate the permission into the guideline, but 12 years later, that has not yet happened. Staff's recommendation would begin that process. That we would be discussing this today was highlighted on the Wednesday CS BAR's agenda. I started a minor brush fire by saying that I had questions about the justification for giving credit and whether the amount of the credited should be limited at least. That may have motivated this morning's public comments in favor of implementing the permission as it is. My concerns are about the potential reduction in the breadth of legal education. More educational time spent on bar preparation is less time available to take electives that would broaden the scope of one's legal knowledge. Many people express concern that our elementary and secondary schools are just teaching to the performance test rather than giving students a broader range of skills and knowledge. I have the same concern with regard to our law schools. Staff began a survey of our law schools to determine which of them are currently giving credit for bar prep courses. 3 of the 10 schools that have responded indicated that they are doing so. The others were not. That's less than a complete set of data, however, but I believe they are still working to gather information from the schools that have not yet responded. In any event, today is not the day to resolve this. The recommendation is to send it to CS BARs for discussion and a recommendation, as we normally do with any changes to our rules or guidelines. With that in mind, I have a proposed modification to the motion, to the proposed motion that's in the materials that would address my concerns. Natalie, did you want to put that up?
Yes, please. And Audrey, that'll be the A version.
Okay, that doesn't show the changes. So let me put up my version, which will make it easier for people to see. Is that showing okay?
Yes.
Yes.
Okay, so now you see underline and strikeout, and you can see what I did to the second paragraph. The idea here is to just not necessarily change things, or but to have a discussion. You know, nobody's around from 12 years ago, and then present a balanced discussion of the pros and cons for this particular proposal back to us at some point. I changed the date to August because I'm planning on being at a on a cross-country bike ride, and we'll probably miss our June meeting. That's the only reason for that change. But I would like to be there, especially as I'm the guy who started what I'm calling the fire, to be able to discuss it. And so do we have any questions or comments? And a proposed motion, either the original version, which does not include my changes, or this version that asks the CS bars to do more than just say recommend language, but to explain the rationale for continuing this approach.
This is Bethany. I have a question. Was this not discussed in 2009 when they gave this waiver? Like
I guess, but Natalie, can you find any legislative history?
So I was certainly not present at that time in 2009. It was a motion that happened at the committee, but I do not have any history as to the points raised. So we don't have that information. But even if we did have it, it may be appropriate to think now at this time, this moment in legal education, if the factors are different.
Okay, this is a follow-up question because I'm trying to make sure I understand. So basically in 2009, they said that the unaccredited law schools could give their students law school credit for the bar review courses they were taking to study for the bar exam.
I don't think it's like signing up for one of the proprietors like Barbary, but it would be a part of the school's curriculum. Is that right, Natalie?
That's correct. And for comparison purposes, the ABA does now allow that without limit. The accredited law schools have allowed it, the rules have allowed it for accredited law schools if the credits are kept to a minimum. And in the newer, more streamlined rules, the minimum language is adjusted. They're still able to do that. In the unaccredited guideline, it's much more prescriptive as to what the school can do and works to avoid financial conflict of interest or any other thing in that regard. And so those are the types of factors that can be discussed.
Okay, awesome. Thank you. In that case, I'll move on Paul's motion.
Is there a second?
I'll second it. It's Torres.
Thank you, Mr. Torres. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger? Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan? Mr. Kramer?
Yes.
Ms. Lynn? Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriyaba?
Yes.
Mr. Torres?
Yes.
The motion passes.
Okay, thank you. The next item is 0403, a report on administrative updates for accredited and unaccredited law schools. And unless anybody has any questions, I'm trying to remember, Natalie, do we even need a motion?
Mr. Kramer, can you please stop your screen?
Oh, sorry.
No, we don't need a motion as to that page. That's solely informational.
Okay, does anyone have any questions? Okay, then the final item is our goals for this year, 0404. Dean Frickberg, who is the chair of CS Bars, wants to, and we've invited him to provide CS Bars feedback regarding our goals. Can we activate his mic?
I'm sorry, who are we going to speak to?
Dean Frickberg, he is the chair of CS Bars. And they have been talking about our goals at that level. So we've invited them to provide us some comments.
So by way of background, the educational standards goals were adopted at the prior meeting, one meeting ahead, so that they could be brought to the Law School Council and CS Bars joint meeting in December. They were discussed there to help determine what sort of feedback they had and what sort of additional information they could provide to the committee to help you in your work this year. And Jay Frickberg will be speaking on behalf of not only CS Bars, but also the Law School Council, as that chair, Devin Kenyon, was unavailable today.
Thank you and good morning. My name is Jay Frickberg. I currently serve as the chair for the CS Bars. I'm also the dean for the University of West Los Angeles, a Cal Bar accredited law school. On December 1st of last year, we held a joint session between CS Bars as well as Law School Council, chaired by Professor Kenyon. Our agenda item E is the same agenda you're currently looking at. And we had a discussion on that. I wanted to just take a moment as part of this process to mention I've had 17 years of working with the committee in education at law school specifically. And I just wanted to commend our group here, especially staff and committee members, as WASC would call it, asking very provocative questions and seeking courageous answers, especially when we talk about diversity, equity, and inclusion. I think this is what we should be talking about and what we should be focusing on. But part of this discussion was the newly adopted rules. One of the pillars for the newly adopted rules for accreditation is 4.160C, which focuses on diversity, equity, and inclusion. To that point, I'd like to just point out agenda item 0201, the data from it, as well as the California Bar's second biennial report on diversity, equity, and inclusion, showcases the following. The California population self-identifies at 36% Hispanic. The bar's membership is only 7% self-identified Hispanic. Yeah, that is stunning, I think. I think that should stun all of us, that disparity. If you compare that to the July exam, the first time examinees from the ABA, 12% self-identified as Hispanic, and from the CALs, 18%. So there's improvement there for the next generation. The same can be said for in California, those that self-identify as Black. That's 6% of our population in California, again, according to the California Bar reports. And our membership is only 4% self-identified versus the California ABA in July, first time, 3% versus the CALs, 7%. So I'm pointing this out because I think it's something everyone here should be justifiably proud of, that you're part of, as the accreditors for the California accredited law schools, a difference, a change that needs to occur and is finally occurring, as evidenced by our committee. Also, I'd point out, similar to what Dr. King said 60 years ago at his address to Cornell, we've come a long way, but there's still a long, long way to go. And I'm hoping that from the discussion today, that will continue, especially as evidenced by the conversation we just had on Guideline for the Unaccredited Registered Schools 1.11. Again, huge disparity compared to 17 years ago, conversations with the committee versus now. I hear a dialogue going back and forth. Committee member Kramer and I will disagree on some things, but we have conversations, we have dialogues, and I think that is excellent. So I just wanted to report on that. Thank you.
That's it.
Great. Thank you, Mr. Kramer. Thank you, Ms. Leonard.
Oh, wait,
Ne-
no, I was
Oh.
asking if Dean Frickberg had concluded.
Okay.
That was it for me, yes. Thank you.
Okay, thank you. So you had no specific recommendations for changes to our goals?
None. I think from our discussions at CS Bars, they're evidence of the conversations that we're having right now. Thank you.
Okay, thank you. So then, if there are no questions about the goals,
Can I just, I really enjoyed that. I enjoyed the statistics that he was providing. Perhaps we could keep up with these statistics at least once a year. You've worked yourself into a position here, Mr. Dean Freiberg, but I think it's important for us to know how the Cal Accredited and Unaccredited are doing and what their statistics are with respect to serving their respective communities and the number of minorities that are being served as well, and perhaps including the bar pass rates. So I think that perhaps we should consider that being a goal going on forward with this particular committee.
yeah, I think that's a good idea. We can, over the next couple of years, we're going to be gathering more information, types of information. So it'll, we'll have an incomplete data set for the last few years. But Amy, or do we, to what extent do we have some kind of tabulation at this point? And first of all, which committee would be the appropriate one to be tasked with that? Perhaps producing at the end of our committee year statistics about the number, the nature of bar passers, and then also law students in the schools that we regulate.
Well, we compile statistics at the end of each exam. And what we don't have right now is the integration of race and ethnicity by school type, because we do have statistics on the pass rates for school types. One of the caveats to that is that, unfortunately, we don't supply data for any school that has less than 10 in that pool of applicants for the purposes of protecting people's ability to be identified, right? So less than 10, if you have less than 10 ideas, that it would be easy to identify who a passer is and who isn't. And so as a result, that would be one of the constraints in developing this. That is, if we wanted to get more granular in that report and look at the pass rates and then break that down by race and ethnicity, the one concern is that when those cells get to less than 10, which really is possible when it comes to the registered law schools and accredited law schools, because those testing populations are small. But in terms of perhaps reports looking at other key indicators of law school student retention, perhaps developing reports related to how many students are, we collect that as part of our annual reports, but I think the request here is to aggregate that on an annual basis, so we can see that statewide, the number of perhaps students registered, how many have continued, how many have graduated, and then perhaps maybe even look at the graduation rate by race and ethnicity, and then look at how many of those were unable to report based on that cell size. I think that's feasible. I think it would be a joint effort between the exam subcommittee working with Ed Standards to access that data.
Okay, but if you aggregate the individual schools, the small ones, the small cohorts into a total, say for all the registered schools, and then one for all the accredited schools, that would eliminate the concern about disclosing individual details, correct?
Absolutely, yes, that's one
Okay.
method.
And you do keep the data for those small cohorts, you just don't report it that way.
Yes.
Okay, yeah. So I can't recall that we ever, maybe that report's available somewhere, but we don't get it put in front of us, and therefore we don't see it. So could we maybe make it a habit of doing that at the end of each I don't know if the end of a committee year is the appropriate time. It may be that maybe it's done on an annual basis, but once a year we could receive that information as an agendized report. So then we could see it.
Yeah, I think we could create that deadline around, or that delivery date around the time that the reports are due, which is in the fall, right, Natalie? I think she's.
Yes, yeah, they're due in the fall, and then it takes time through the holidays and early winter to process them. So it's something that we could bring to you in the sort of the first part of the new year.
And if you have an obligation to report this to somebody else, like the Supreme Court, I would suggest that for convenience, we coordinate with that date, so we're not making you do it twice during a year.
Paul, if I may, I hear what everybody's saying, and I am aware of the statistics that are provided after each bar exam, but I'm just talking about some of the certain metrics that were mentioned by Dean Freiberg. I thought were quite interesting. And I go back to something that was said by Kareem about a year ago, where he said that as a public member of this organization, what he wants to know is whether or not people in his community are in fact participating in these schools, and if the percentage of say minorities are down, why is it down? And I think he mentioned having information, that information like this was vital. And I'm just paraphrasing what Kareem said about a year ago, but I do remember that. I thought about it when Dean Freiberg was talking, but perhaps also I like the fact that we have the chair of CS Bars actually presenting this information, so that if some of us have questions about it, we could inquire of him right away, rather than have a member of the bar staff provide that information.
Okay. Any other questions?
Can I
or
chime
comments?
quickly? Paul? It's Kareem.
Sure.
Mr. Torres, thank you for making me sound very intelligent. I really appreciate that. But yeah, I did want metrics regards to the unaccredited registered law schools in our communities, and identifying the demographics, more so understanding our pledge for equity. And I know, and I really appreciate Dean Frickberg's work, and Natalie, as well as yours, Paul, on continuing those efforts. That's something that I think is very important, because a lot of the conversations that I had early on with our registered law schools is about their opportunity schools. And so for people doing second or third careers, it's a more affordable and practical option for them. And I'm noticing that our schools are nestled in communities that need that support and have a lack of representation. So if there's a way, I know during those early discussions, we were having back and forth regarding how that data would be compiled, and not placing too much pressure on the institutions. So I'm just trying to find the middle ground of how we could get that information provided, and just ensure that we just capture what we're doing well. And Dean Frickberg will be the first to tell you that there's stuff they're already doing. And we just need to underline and highlight it. And maybe that will be what it takes for us to begin that data process and presentation.
So if I may, I think we have all of that data. It gets presented to you in a whole bunch of different ways. And what you're asking for makes sense. Let's pull together for you in a comprehensive report the data that the schools already provide to us now, and we've been changing those reporting structures that the California Accredited and the registered schools provide on the composition of their class and attrition rates and information such as that, combining that with the attorney population information, the comparison to the California population, as well as the bar pass statistics by school type and demographic. So we have that in a lot of different places, but we haven't put that together in a comprehensive sort of single report for you that makes it easy to put all of those pieces together. And we can easily make sure that happens annually.
Yeah, Donna, I'm thinking something like an AIM system. Of course, not as technical and complex, but something that's, I guess, capturing and reporting that data. And my side of the world, we use Teams, not Teams, but Microsoft to help build those reports. So I'm sure you guys have some capacity to figure it out. The only issue was just how do we get that information from the institutions and then plug it into something that could interpret it and provide data visualization for us.
Yeah, I think we have what we need from the institutions. We've worked very hard with J and CS bars and the other California accredited and registered law schools to improve that reporting. So it really is just a matter of giving you the comprehensive report. But I think we've got the data, and you know, Amy, Audrey, Natalie, and I can go back through what we have and just make sure we've got something to compile. But I think I do believe sincerely that we have all that information. It's just put in different formats because we hadn't thought about putting it all together in a single visualization, but I think we have it.
Kareem, to address your concern about burden on the schools, the good news is we're in the second year of the data expansion, and it's been going very well. It's been a very successful collection. And interestingly, the only comment that we received in terms of student comment was a request to expand the collection further. And it was terrific to see that the expansion that they asked was actually an expansion that we already had planned. So we were concerned about how it would be received, but the schools have responded very well. The students have responded well and have in fact asked for more collection. In addition, what we might include is actions we've been taking and the schools have been taking based on the data that we've seen too, because it's terrific to know the information, but even more so to use it and amplify the progress.
Thank you for that, Natalie, and I appreciate your work in all of this. And I'll say it, I think we have a hidden gem in the state of California and in our jurisdiction by having these schools under our purview and having access to this information because it becomes our story of how we provide opportunity and have this unique process that enables it. So yeah, whatever we could do to highlight that, underline and stick an exclamation mark on it, I would love to see it and be helpful in any capacity that I can. Thank you.
Okay, are we, any more questions or comments on the goals? Natalie, you want to put up the motion?
So moved.
Mr. Kramer, can you please state the motion?
Oh, state it. Move that the report on the 2021 to 2022 educational standards goals be approved.
Thank you.
I will move.
Mr. Torres?
I'll second Mr. Torres.
Okay, thank you, Mr. Gongora. Dr. Bolton?
Yes.
Judge Brody?
Yes.
Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger? Judge Herman?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan? Mr. Kramer?
Yes.
Ms. Lynn? Ms. Pick?
Yes.
Mr. Torres?
Yes.
Sorry. Oh, Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
The motion passes.
Okay, that's it for Ed Standards. Thank you all. Thank you, Natalie.
Thank you, Paul.
Thank you, Mr. Kramer. Thank you, Ms. Leonard. The next item, moral character, Mr. Reyes.
Thank you, Alex. We went over a good portion of this in the planning, but to reiterate, and we seek the approval from the committee. So the background on this is that we're really focused on training. So we've already completed our PTSD training. We will be receiving a presentation on bias in moral character, and I think that would help to reinforce our previous discussion. We're also going to be looking at court cases that have already happened that are relevant to our determinations. That'll happen in March, hopefully. And additionally, we'll be receiving more presentations on ethics schools and client trust accounting, better to understand that curriculum and how that would apply to when we send people or applicants to these courses. In June, we'll be looking at the revised admin rules and how they relate and affect moral character determinations, so we can get a better alignment there. We'll also, in June through August of this year, also receive additional trainings on other topics related to determinations. So ongoingly, we'll keep conducting the administrative reviews on these adverse moral character determinations from the staff, and then bring those forward to the committee for final discussion and vote. Okay, so that's it.
Mr. Reyes, can you please state the motion?
Yes, the motion is to move the report on 2022 moral character goals be approved.
This is Bethany, I'll move.
I'll second. This is Robbie.
Thank you. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Judge Herman,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
the motion passes.
Thank you, Ms. Wong. So at this time, we are going to be going into closed session. However, I just want to mention to the public that we do have one additional item remaining in the open session. It's the training on the principles of scaling written test scores from Roger Bolus at 2 p.m. So we'll be returning back in open session at 2 p.m. For the committee members and State Bar staff, please leave the open session and join the closed session. You should look for an email from Ms. Wong with the subject line closed session with the appropriate link. So again, thank you. I will see the public back in the open session at 2, and for all other attendees, we'll see you in the closed session now. Thank you. Okay, welcome back. We're here in open session, and we are going to continue with an item from examinations. It is the training from our subject matter expert on the principles of scaling written test scores on the California bar examination to the multi-state bar examination. And I'm looking to see, I believe, Roger, you're somewhere on my list here. Are you there?
I am.
Just what? Yes. So we have Roger Bullis, who is here, and he has been, he's a great partner with the State Bar and has done presentations in the past. So Roger, do you mind? Well, actually, I'm going to ask Amy, do you mind introducing Roger?
Sure, no problem. So we've been waiting for this presentation. I think that we proposed to do this a few meetings back, but it's perfect timing. I think this presentation, some of you may have heard this before. This presentation is about our scaling process. And Roger has been working with the State Bar, conducting grading and any analysis as a need arises for over, I believe, 20 years. And so today what we're going to hear about is the process that is used when it comes to scaling. And I think it'll shed some light on the current situation that we are in terms of evaluating whether we could go remote, and that would require, given the parameters around the NCBE, it would require that we not have an MBE, and what the implications of that would be. So with that, I just want to introduce Roger or allow him to give a little more background on himself and start that presentation. So Roger, thank you for being here today.
Thanks, Amy. Can I share my screen at this point? Kim, is that possible for me to share my screen?
Yes, shouldn't be a problem. No one else is sharing at the moment.
Okay, everybody see the my home screen here, okay?
Yes.
Great. Well, thanks for the opportunity. I've spoken to the committee several times in the past on the bar examination, and Amy requested this time that we drill down on the topic of scaling.
May I interrupt? May I ask if Dr. Bullis, how you doing? Can I ask if you could speak to the mic, please? I'm having trouble hearing you.
Is anyone else having trouble hearing me?
Yes, it's very difficult to hear.
Let's see. How about now?
For me, much better.
Okay.
Much better.
Good. All right, good. I'm moving on the screen a little bit to get to my speaker. So scaling is a somewhat involved topic. So I'm thinking that it's important to understand the concept of scaling in a slightly broader context, and then drill down on it from the orientation of a bar examination. It's a very, very important topic. As Amy mentioned, you're going through some of the pains of what it might be like to operate without multiple choice tests. You need to recognize that virtually every state in the who administers a bar exam in the U.S. uses scaling in its scoring, much the same way that we do. Since there's some board members are new, Amy indicated, she asked me to give you a little bit of a background on myself. I'm going to give you a minute or two on the notion of measurement and some definitions. And many of you have seen a couple of these slides on testing standards, but it emanates from the Scaling emanates from one of the standards that's at the core of licensing examination. I'll give you a couple slides on the composition of the bar exam, which you're probably well aware of, but you'll see where scaling actually fits in. I'll talk a little bit about why and how it's done, and then got a couple of examples on the impact of scaling on examination outcomes, and a couple of housekeeping matters. Amy, I'm not sure how you handle questions, but I was going to suggest that maybe we go through the presentation. If people have questions, they can route them to you or Kim. I'll let you make the determination of that. And then at the end, I'll try to go back and answer those questions. If
That
that
sounds
works.
like a plan. Yes, I will alert you towards the end of the presentation when questions arise.
Okay. And I want to note also that the slides here are somewhat, they're called content heavy, because since this was intended as a tutorial, I wanted to leave you with enough detail in the slides that you can refer back to them. I'll forward the entire slide deck back to the staff after the presentation is complete. So I may not hit every point on the slide, but you'll get an understanding as you go back, so you'll have something to back reference to. So in terms of me, I'm a psychometrician by training. I graduated from UCLA back in 1981. And a psychometrician is somebody who practices the science of measurement or psychometrics. And psychometrics is basically the science of measuring individuals' psychological attributes, which include knowledge, which were basically knowledge and skills, which is basically where the bar exam sits. As Amy indicated, I've been working with the state bar since the late 70s, and perform a whole panoply of activities. We do a lot of quality control work. We do statistical work, including derivation of scale scores, and which eventually result in pass-fail regrade decisions. We prepare a lot of diagnostic statistics on the grading teams to help with greater reliability. We are involved in reporting, and we consult on a lot of ad hoc issues that have arisen, which unfortunately in the last couple of years has been fairly significant as the exam has kind of morphed into remote testing and all of the issues brought on by the having examinees sitting at home in front of their computers and all of the issues that that's brought up. We do perform annual reporting. I see that the acceptance of the annual report or the exam specific report is on your agenda today. We prepare those just to ensure that the exam has met technical standards. And we do maintain historical databases for psychometric studies. This map gives you a little indication of the states in which that we've consulted with since back in the early 80s. Those in black are states that we do very similar work with on an administration-specific basis. And those in green are states that we have consulted with over the years. So to move into the meat of the presentation, a couple of definitions that I think are relevant here. The first is measurement. I think it's important to have a sense of where we're starting from. And all measurement is it's basically the process and procedure of assigning some categories, and we're particularly concerned with numeric categories to objects according to a specific set of rules. In scaling, from a mathematics perspective, is the process of placing the numerical categories on some predefined continuum, possessing known properties. And if you just hang on to some of those terms, because as we get into scaling on the exam, we'll call back on those. I thought a quick slide here to talk about the types of measurements that are available. And we basically divide up the world on the right here, qualitative measurement, which is just basically defining properties or characteristics of an entity, such as hair color, brown, blue, green. That's considered part of qualitative measurement and ordinal. Where we operate is more on the quantitative side, and basically what we're using is numbers to help define the constructs that we're interested in. As we move down here, we move first down to the notion of continuous measurement, and that involves things such as height and weight. We move down further to the concept of ratio measurement, and that's where bar exam scores reside. The notion of ratio measurement is such that we have predefined categories along a continuum, and within those categories, we have subsets of numbers such as decimals. So we think about an initial scale. Everybody's fairly familiar with the measurement of temperature. We here in the United States use Fahrenheit. Scientists use the Celsius scale and the Kelvin scale, but you'll notice that there is a direct one-to-one correspondence between specific points on each of the scales. So for example, boiling water on the Fahrenheit scale is at 212 degrees, but on the Celsius scale, it's at 100. And on the Kelvin scale, it's at 373. But you notice the bottom of the Kelvin scale is 0. It's minus 460 on the Fahrenheit scale and minus 273 on the centigrade scale. So again, 3 different scales of measurement, all intended to measure the same thing. And one aspect of the association between these 3 scales, or something that we'll run into when we talk about bar scaling, and that is that it's a linear relationship. We can calculate Fahrenheit by, if we have a temperature on the Celsius scale, by this formula. It's 9/5 times that plus 32. So you notice in this linear transformation from one scale to the next, it's characterized by 2 things. One is a weight, here it's 9/5, and then a constant of 32. Similarly, going from Fahrenheit, from Kelvin to Fahrenheit, we have the same thing. Going from Celsius to Kelvin, again, it's the same thing. The weight here is implicitly a 1 and the constant's a 273. So what we have is in scales, there's always a relationship between different scales measuring the same construct. And the key issue here is figuring out what that mathematical relationship is. So if you can hold on to that for a few minutes, I'm going to take a quick dip into the notion of testing standards. And you'll see the link between scaling and these standards in a second. Licensing examinations themselves are guided by the standards for education and psychological testing. The guide was initially put in place in '54, and it's been maintained for over almost 70 years now, and it's in its 7th edition. The standards are jointly maintained by American Psychological Association, the American Educational Research Association, and National Conference of Measurement and Education. The value of the standards is that it is based in measurement theory, and that theory has continued to develop since I was in graduate school. But it's also based in real life testing situations. The 300 some odd standards can be summarized into these, what I consider these 4 cornerstones. And I put these cornerstones on a scale because in any testing situation, we're always balancing these 4 constructs. Validity, which evaluates whether the test is measuring what it's supposed to measure. Reliability, which addresses whether or not scores resulting from the test, are they stable and consistent. Fairness is the content and the procedures of the testing and scoring unfairly disadvantaging subgroups. And it's within this context of fairness that we start addressing the concept of scaling. And I'll talk to you a little bit more about that. And then cost effectiveness, asking the question, are testing costs appropriate and are test takers' time being used efficiently? So in the perfect world, you would have perfect validity, perfect reliability, fair to everyone, and we're doing this on an extremely cost-effective basis. We don't live in a perfect world, so we're always making trade-offs amongst these four constructs. So moving into the California bar itself, we'll talk about, first I want to talk about composition and scoring, and that'll give you a little bit of a drill down as to where scaling comes into play. We do know the exam now is basically 1 day of testing written content. That's on the first day. 5 written essay questions and a performance task. And the second day consists of the multi-state bar examination, which is 200 multiple choice items, 175 of which are actually used to score the exam, and it covers 7 topic areas. After the exam is administered, goes in, the written sections go into grading. Now have basically 6 groups of over 16 trained graders, and those graders are grading the examination on a scale not from 0 to 100, but from 40 to 100. It's a bit of a vestige, but from days gone by, but basically it amounts to approximately a 13 or 14 point scale. And as a pre-activity to beginning grading, our graders are involved in 3 calibration sessions, all intended to ensure consistency in the grading. So this starts getting us now down into our score calculations. I highlight here the difference between a raw score and a scaled score. The raw written score is simply the addition of the number of points assigned to each essay question and 2 times the score assigned to the performance test. So implicitly there is a 2-to-1 weighting on the on the performance task. So that comes out to a maximum of 700 points. So the raw written score itself is scaled to the average and standard deviation of the MBE distribution. And I will explain what how we do it, why we do it, and what happens when we scale that score. Those two scale scores are then multiplied by 50% each. That 50% is what we call a nominal weighting. We say we want each of the sections weighted by 50%. Mathematically, it's critical that the scores be scaled so that that 50% weighting on the scores can occur. We call that the effective weighting as opposed to the nominal weighting, because at the end, if we have time, I can explain to you the difference of why it's critical that both sections of the exam reside on the same scale of measurement if we want to retain that 50% weighting. The other reason why we scale, obviously, is it would be impossible to add a scaled MBE to a raw essay score. They're basically at that stage are on different scales of measurement, similar to the fact we couldn't add or average, 5 centigrade temperatures with 3 Fahrenheit temperatures without putting them on the same scale of measurement. So a reason number one for scaling is to allow us to do what we call our compensatory decision-making, which is allowing performance on each of the exam sections to contribute to the total score. It allows higher performance on one to compensate for lower performance on the other section. And so, again, we've just recently dropped our passing standard to a 1390. Someone in the initial grading, if someone falls within these two ranges, we do go to a phase 2 grading, and our final decision is greater than a 1390 is a pass, below is a fail. So here's actually an example from an applicant taken from an exam a couple of years ago. This applicant scored fairly well, 75 on the first question, and so on and so forth, and scored a 70 on the performance task, yielding a raw score of 455. That's 455 was then subsequently scaled to a rather high written scale score of a 1537 using this formula. Each exam, and this is called the scaling formula, and I'll show you how we derive it. And basically what we do for every applicant, after we derive that scaling formula, we put their raw written score into the formula to derive the written scale score. So this particular applicant ended up with a 1488 and they passed. So the mathematics here, simply a lot of addition and multiplication. So quite simple. The meat and the statistical issues come in the derivation of this scaling equation. So why do we scale and how's it done? As I mentioned before, the standard of fairness dictates that the examination retain the same level of difficulty over time. In other words, we want people of equal ability to be able to earn the same score independent of when they sit for the exam. So in other words, we've put our passing standard at 1390. So if a person earns a 1385 2 years ago on the exam, and they earn a 1385 on this exam, we want to ensure that they are of equivalent ability. And we don't want a person's estimate of ability, which is basically their score, to be impacted by how difficult or easy a particular examination administration is. Now, essay exams, while a lot of people consider them to be the most valid of the sections on the exam, it's very hard to control the difficulty level for several reasons. One, we cannot fully pilot the written questions before test administration. We go about as far as we can during the development process. That's the first issue. Second of all, graders, no matter how much calibration occurs, can differ over time. Differences, and that's within a grader themselves, and also between graders, two different graders grading the same question. Some can be a little bit more lenient, others can be a little bit more stringent. So our concern is whether or not the resulting scores are a function of the actual examining ability, question difficulty, or grader tendencies. Now we know multiple choice exams don't suffer the same problem as essays, tend to be more reliable, but again, they probably suffer from a little bit of the validity issue. So hence, that's why we have multiple sections, not only for this notion of scaling, but also to balance the validity and reliability. And the reason why multiple choice exams end up not suffering is because there's a rather large science about piloting these items before they're administered. Again, that's why the MBE only has 175 live items. Every examination, they're piloting an additional 25 questions so they know where to improve these questions and when they can add them. There's only one correct answer, and the reality is it's much easier to use reuse MBE items because there's such a large volume. So basically, and this is what currently the National Conference of Bar Examiners are doing, is they are going through a statistical process called the equating that ensures that the scale scores coming out of their exams mean the exact same thing. And the process of equating is done via placing a set of items that have been administered in the past and knowing what the characteristics of those items are and using those as anchors to compare the test performance. So basically a test that has in which the equators, or those common set of items, are one set is easy, has lower performance than the other set, provides insights into whether that MBE administration is more or less difficult. And the statistical process of equating then goes through and makes the adjustment and results in a scaled score. So a 1420 in July of 2020 means essentially the same thing as a score of 1440 in February of 21. So using that as a foundation, essays can be placed on the same scale of measurement as the scaled multiple choice test. Basically what happens is we map the distribution of everybody's essay scores onto the distribution of the MBE scores, and allows us to control for the differences in the proficiency levels of the different groups of test takers and the differences in the difficulties of the essay questions and graders. And then subsequently, as I showed in the previous slide, allows the written scores and the MBE scores to be added together. So I don't want to bore you with a lot of the math, but what we're seeing here is basically the equation to come out with an examinee's scaled written score. What's in yellow represents written score information. What's in green represents MBE score information. So first in the calculations, we take an examinee's individual written score and we subtract from it the average of all written scores. And then we divide that by the overall score spread, or what we call the standard deviation. Basically, all the standard deviation is an indicator of how broadly the scores are spread out. So if you look at this formula real briefly, this aspect is what we call developing a standard score for an individual. So if the individual scored at the average, that numerator would be 0. So no matter what we divide it by, it will end up being a 0. The higher the examinee's written score is above the average, the higher that this one calculation will be. Above 0, if he's below, he's going to end up with a negative score. Once we have that, we then multiply that by the MBE standard deviation, and that's all examinees in California. And then we add to it the scaled MBE average. So as we look at this formula, just to get a kind of a visceral sense of what happens, the higher the performance on the MBE, what we infer from that is that this becomes a much more able group. Because again, recall that the MBE scale scores already been adjusted to account for differences in the difficulty level of the MBE. So this one factor will tend to drive the overall average on the examinations. And it stands to reason that a more able group would be able to perform better on the written exam. We know that the correlation historically has been quite high between the written and the MBE test. So again, here we have a multiplier based on the standard deviation, and then basically add the scores. So this is actually the formula that we physically start with, but I'm going to redo the math a little bit, and I won't dwell on this. Here's that same formula. The average essay, the individual's essay minus the average, divided by the spread of the essays times the MBE's standard deviation plus the average. So we can redo some algebra, and I'm not going to go through it here. There's no need to do a proof for that in a math class, but we can derive the weight, weight by dividing these two, the score spreads on the MBE by the essay, and we can get a constant by this particular formula here. And what that results in is that the examinee's scaled score is a function of the weight times the raw essay plus a constant. And if you think back to when we were doing a linear transformation on the on our temperature scales, going from a Fahrenheit to a centigrade, we multiplied the Fahrenheit by a factor and added a constant to it. And this is exactly, it's the same notion. The difference here is that we don't have physical measurements that are perfect. We have measurements that have some error in it, and these formulas are basically designed to account for the differences, account for that error. So let me give you a graphic view of what's going on. So this is actually from the July 2019 exam. And here's the raw written scale. And it runs from, with an average of 425 and an average score spread of about 37 points. You know that, and these tend to be normally distributed, which means that about 68% of the people fall within this plus or minus one standard deviation. So this point here represents one standard deviation above. This is one standard deviation below. This is two standard deviations above. And by the time you get out here, you're coming for about a little over 95% of the applicants. So on this particular exam, here was the MBE scale. Its average was a 1428 and its score spread was 165. So from here to here was 165 points, one standard deviation. Here's one standard deviation below, and so on and so forth. So when we scale somebody who has a 425, we crank it through our formula. That person will have a scaled written score of roughly 1428. If we have an applicant who on the raw scale is one or standard deviation above or below, that person's score will scale to either the 1593 or 1263, basically one standard deviation above or below. And similarly, if there are two standard deviations below, which is very poor, or at 499, which is two standard deviations above, they will scale basically to two standard deviations above on the MBE scale. So basically, that's all that's happening in the scaling process. We're mapping scores. We're mapping the distribution of the written scale, raw written scale onto the MBE to come out with our written scale score. And point to take home is after we go through these machinations, where the person scores relative to other applicants on the written score has not changed. They are still basically the same distance away, and the performance on the scaled written distribution as they were on the raw. So all we were doing is this mathematical operation to ensure that we have comparable scales. So what's the impact of scaling on an examinee's outcome? And why can't we interpret a raw score on the essay directly? So I'm gonna paint you a couple of scenarios here. And I'm gonna take an examinee, and he sat for a theoretical exam. And this applicant scored a 406 on the written score, and he had an MBE of 1370. So it just so happens that on this particular exam, the average was 406, and the MBE average was 1370. So our examinee scored at the average. His So this is the group average this is the group average on the two sections. So when we perform the scaling, since the applicant was at the average, his scaled written score scaled directly to the average of the MBE. So he had a 1370 written scaled score. When we calculate his scaled total score, this applicant fails. So let's assume now the applicant A decides to take the exam next administration. And the next administration has an easier written exam. And we can tell it has an easier written exam because the group average went up. So so what happens to this applicant now, because he still scores a 406 and he's scoring the same exact scores as he did in the first exam. His score is below the average this time, same MBE. So his written scale score actually ends up lower than it was in the previous exam. So he still fails because his total scale score is now 1345. And this is reflective of the fact that the written score on this particular examination was actually a little bit easier because the group was about at the same level of ability based on the MBE, yet the average score went up. So our operating assumption is that it's a slightly easier exam. So here's he sits yet for a third examination. He still scores a 406 and a 1370. But this particular written examination had an average score of 384. So his score of 406 is significantly better than the average. So we now know that he's done much better on this examination with his 384, even though on the he's with his 406, even though it's the same that he scored on each of the exams, but we know that the average difficulty level for the essay was much harder, as evidenced by this 384. So when we go through the scaling operation, now his written scale score has gone way up, meaning that a 406 on this exam is much better because it's well above the average of 384. So now we put these two scores together. He's at a 425 and he actually passes the exam. So for each of these three exams, he had a raw score that was exactly the same. But what was happening during these three exams is that the difficulty level of the examination, or the written examination, was changing. So if we relied on somebody says they had a 406, it means virtually nothing unless you know A, how difficult the particular exam was, and B, the general performance or ability level of the examination on the MBE. So a couple other exams or examples here, all of a sudden we have a much less able group as looked at by this 1320 on the MBE. Still has a, the raw written average was a 406, and the examinee actually, this particular examinee fails because now his 406 will scale to back to this 1320 level, and he fails. And the final example is, now we know this fourth group, he's scoring, this is a much more able group. The average on the essay was a 406, but because it was earned by a much more able group, it ends up scaling to the 1410. And if you can recall back to the formula, this 1410 reflects the overall average of the MBE. We add it to his 1370, and he ends up with a 1390 in passes. So the takeaway on all of this is that relying on the written scores alone can mean very, very different things from one exam to the next, unless you know, A, how difficult the written examination was, and B, what is the basic ability level of the overall population of examinees. Now, again, this is a theoretical example, but again, you can see here is that the calculations on any given exam can result in a very different outcome. Now, what this graph is, I'll just, if we can kind of focus on here, is what I did do is I went back into our archives and took a look at our the results of our scaling over the last 4 February exams and the last 5 July examinations. And I said, well, what happens if an applicant had scored at, had an average score of 55 on every question? This red line represents the passing score of basically 1390. We can see that, you know, from basically from here down to here is the different scale score points that 55 would have been scaled to, depending on which exam they sat for. So in other words, they would have failed on, somebody with a 55 would have failed on any of these seven administrations. Here it is at an applicant with a 65. So anybody with a average score of 65 back in February of 18 would have scored just below 1550. Here in July of 19, they would have scored about at a 1570, and they would have passed at about, they would have passed on any of these examinations. An applicant who had a average score of 60 would have failed on these particular examinations, but on the July 19 and July 20, they would have passed. And the reason for this is that the examinations during those 2 administrations might have been a little bit harder. They wouldn't have passed by a lot, but they passed by a little bit. And the overall performance or ability levels on the of those groups were a little higher, which essentially ended up scaling their scores upwards. So the takeaways regarding scaling is that one, it maintains score comparability across examination, not on raw scores, but on scale scores. It addresses 2 fundamental psychometric issues with written tests, is that questions can be difficult no matter how hard the developers of those questions try to keep the difficulty levels consistent. In the absence of being able to fully test that, we don't know that going into the exam. And despite every effort to calibrate our graders, human nature is such that leniency can change either within a grader as they grade over time or between graders. Our numbers over the last couple of years with the new reports that we put in have shown that our graders are very effective at maintaining their levels of calibration throughout the grading process. So any differences that we're seeing are more likely a function of the inherent difficulty of the questions rather than the differences in our graders. And the final point is that scaling solves some mathematical issues as we engage in compensatory scoring. It puts all the scores on the written scores and the MBE scores on the same scale of measurement, so we can add them. And it ensures that the nominal 50-50 weighting, which you all decided should be the weighting of the respective sections, becomes the effective weighting, so that we now have complete confidence that the written scale score is contributing 50% to the applicant's grade, and the MBE is contributing 50% of the weighting. This would not be possible using basically raw scores. So went through a lot of material here, and I will try to answer any questions that y'all might have.
I'm looking for raised hands. And I don't see any, Roger.
Paul has a question.
I either completely snowed everybody or put them to sleep, or I did a great job and they fully understood.
Well, actually, we have one question, Paul Creamer.
Yeah, but Roger, it is restful. So maybe you covered it and I glossed over it, but address your scaling presumes that the MBE is able to moderate keep their difficulty at a particular level, or at least to notice relative performance differences between taking classes. How is it that they do that again?
They do it through a process called Accredited. We have to recognize that you can't give the exact same MBE test year after year after year with the same questions, because there'd be a concern about the security of the test, right?
Yeah,
So,
they would gradually get better at it.
exactly. And so basically that would mean that it's not applicants, you're not measuring applicants' ability at that point over time. You're measuring how effective people are at getting access to the questions. So by its very nature, the type of licensing testing that's going on, tests have to change year over year. So again, one of the standards are that every administration of a test, the resulting score should mean the same from one exam to the next. And so that means that the difficulty level of the test somehow has to be controlled. So what the national conference does is they embed upwards to about 20 items out of their 175 that have been used in the past. And so they know, they look at the attributes of those 20 items and they know what performance is like. So they could see what past populations have performed on that set of items. And then they look to see what happened on this administration on those 20 items. So if the applicants perform better on those core set of 20 items than it was in the past, then the assumption is that this is a more able group, and they then statistically use that to adjust the balance of new items to derive the scores. And then they map those scores back on the old scale scores that have occurred in the past. So that's where there's a little bit of leap of faith there for people who aren't statisticians, but this has been a pretty tried and true method of doing it. So the follow-up assumption is that if we've got a reference distribution where we feel 100% confident that that has controlled for any differences over time, that this particular scale on the MBE really is a good indicator of the ability levels of the applicants. And so that way we can map our written scores onto that distribution.
And do they scale their own scores on the basis of these the
anchor items?
Yeah.
Yeah, that is one thing that the national conference does. They've got people like myself, but they have an army of them. And they go through that process once all of the results are in. Now, somebody has asked at certain points, well, is that fair that we're included in that group? California applicants are included in that group. Actually, it makes it stronger because they have basically more evidence. The more people they have in there, they've got a better sense of what the overall skill levels of that are. And remember, it's only being used not necessarily to change the measurements of the individuals, but to ensure that the properties of the measurement scale itself is accurate.
Yeah, I think I'm still in the faith category.
Yeah, it's apart from the one has to it's been examined. It's kind of basically now an accepted principle in psychometrics that is the other point which makes it allowable to scale to that distribution. It's not as though the MBE is measuring anything that's radically different. We know quantitatively that scores on the written test in either the raw or scaled version, because remember, when we scale, it doesn't change the relative standing of the individual. A written score correlates at about a 0.7. Our written score correlates at about a 0.7 out of 1, which is very, very high, which is interpreted as saying that the underlying skills being measured by one test are relatively close to the skills being measured by the other test. If it was perfect, if it was a perfect correlation, then it would be a waste to either administer the written test or the MBE, because basically we get the same information. But because it isn't perfect, and the fact that written tests do measure a unique set of skills, that we have both tests. And again, that's balancing the validity and the reliability, because multiple choice tests tend to be much more reliable because there's no subjectivity in any of the scoring.
What about the gender differences I've heard about? I forget whether it's males or females are better at multiple choice than they are with the written test.
That is true. Multiple choice performance is generally higher amongst males. We've looked at that a lot in the past by a few points, but that's actually counterbalanced by females' improvement or better performance on the written test than males. And that's been age old since I've been engaged with the bar. I mean, it's be it more effective verbal skills being translated to writing abilities, whatever, or the logics required. There's been a lot of study on it. That does not factor into scaling. Those differences they have done studies to show that their equating process works equally effective for males and females. They derive basically the same scale. So when they calculate their equation to convert their 175 points to the 200 point scale, their formulas end up being equivalent, whether or not you're male or female. So they've documented that pretty well.
Okay, well, I'm going for an aspirin. Thanks.
Amy, do you have any questions?
I don't, Roger, thank you. I thought that it would be helpful to have the examples that you included in there, and I really hope that did help. Yes, there we go. Yes. All
Yeah,
right.
because this is basically ends up being, this may have been a little confusing, jumping from the formula to here, but it was intended to show that the interpretation of a raw score can lead to false conclusions. I am aware of a couple states now that do not have access to the multi-state exam in their administration. They're not going to be using it this exam, and I consult with this group, and I've tried quite hard over years to convince them, but their timing is different than when in terms of their exam administration, from when NCBE wants to administer the exam. So they're a bit between a rock and a hard place. They want to administer it on a different platform. So there's a lot of issues. So they've decided, when they're trying to balance everything out, is that they're prepared to rely on written scores to make their decisions. And basically they're relying on the fact that a raw score in this administration is equivalent to a raw score on the past administration. So they will pass applicants on the basis of a raw written score distribution.
Wow. Okay. I think we have one more question. Kareem has his hand raised.
Hi, yes. Thank you for your presentation, Dr. Bullis. It was really informative. I have a question though. I guess it's more towards staff. I know we've received some comment about moving to a universal exam. And with that in mind, we don't know what's happening with well, we know what's going on with the blue ribbon and all the updated monitors and the tests. Do we see scaling being something that's a part of our processes moving forward? Or is this just something that we've kind of inherited and facilitated because of the type of exam that we provide?
So is your question, would scaling continue if we moved into adopting the next gen exam?
Yes.
Yes, I think Roger talked about that early on, is that scaling is just a statistical method for ensuring that the any variance in performance from one exam to the next is measured and accounted for in the grading process.
Okay, sorry about that. I must have missed that spot, but
yeah, no, they will
very
be
informative.
They will most likely, they being the National Conference, will most likely have an examination that has several different forms of questions. And they will most likely have to come up with a method for grading each or scoring each of those sections. And they will face the same issues, independent of what it is, as to how they will bring all of those scores together. And so they will be forced to apply the same principles.
And Dr. Bullis, oh, I'm sorry, I didn't mean to interrupt you. My apologies.
No problem.
Okay, so I guess in your expertise, in your research and your presentation today, are you seeing that scaling is impacting people of color, or is it assisting the bar in being more diverse? Or do you not have maybe the information in front of you that could you could come with that type of hypothesis or conclusion?
It's actually racially, gender-wise, unbiased, the notion of scaling. It's just like this, consider it basically the same as this slide. All we're doing is mapping raw scores onto onto another distribution. Let's put a black who scores a 405 on the written section won't be any further above a white or below a white than he was when he answered the essay question. It's simply a mathematical transformation of his score. So it's somewhat blind to any characteristic of the applicant. The only thing that where the race would come into play is the degree to which, if it has nothing to do with scaling, it might have something to do with the construct of the question, the essay question. All of that factors in before scaling occurs. It's just based on if it's some factor within the question that's affecting his performance on the written question or on the MBE. Scaling in of itself has no impact.
Okay, that makes a lot of sense, because that's where we receive a lot of comment. And I guess in my lived experiences, that's where I've seen impacts. I guess in scaling, I'm going to take it back to when I went to college and the teacher scaled us, for exams and things of the sorts. So I can see it being a beneficial, but based on your commentary, it seems that it doesn't factor in. I mean, it factors in, but it's only a mathematical construct.
Yeah, exactly.
Is that accurate?
I have an example that I have used in the past to show what it is. As a matter of fact, you made me think of it, that I've used in the past to show what happens. It's a example of in college. There's a midterm and a final, and the professor says, "I'm going to weight the final 50% and your midterm 50%," and he gives the test, and because he doesn't scale, his 50-50 weighting just blows up completely. And who's at the top of the class and who's at the bottom of the class is radically changed based on the fact that the final spreads people out much more than the midterm did. And so basically the midterm had no effect at all on the person's final grade. And that's just, it's a mathematical reality. And so the fact that the professor added the two grades together was actually very inappropriate.
Thank you, Dr. Moore. I appreciate that. I know a little bit, that wasn't what in line with your presentation, but I really appreciate your feedback. It really is helpful. Thank you.
Sure.
All right, I don't see any other hands.
And thank you, Dr. Bolus, for your presentation. And I want to thank all of today's attendees, both in the open session and the closed session. I believe we have completed all of our business. So the meeting business has concluded. Hope everyone has a great weekend. Well, first, let me ask you, is there any more business that people, I think we should? No, I do not see so. So again, everyone has a fantastic weekend and look forward to seeing you at the next committee meeting. The meeting is now adjourned. Take care, everyone.
Take care, Chair. Thank you so much.